Maybe a lot.
Yes, sir.
This is item number 14.
1-4.
141.
Huh.
6 time may be given, my lord, to file an additional affidavit to induce two new documents, my lord, we got from RTI. Already in other cases, we have filed, my lord. One of the case fixed for hearing today in court number 18, my lord.
Okay.
We will allow 6 time to file additional affidavit to induce those two documents only.
Mr. M.U. Ahmed, learned counsel, appearing for the petitioner, has submitted that he requires 2 weeks time to file an additional affidavit. List again on
That's for loss of convenience.
13th
13th of
February. 13th of February. Along with the affidavit proposed to be filed. Yes, sir.
Number 46. Item number 46 is a review application pending. The order was passed by Honorable Justice N. Selo. Pendency of the review, my lord, that any order passed in the review will have some bearing in the other connected petitions. But here is that the review is pending. It has to be listed, may be listed before the appropriate payment. Item number 46 is the connected review application.
Okay. Have you informed
Yes,
the
I have informed the
petitioner in 46?
yes.
Learned counsel, appearing for the petitioners in item number
I'm
40.
not responding to the.
For the no in the other cases.
I'm Bhaskar Kumar Das. There are.
In Bhaskar Kumar Das, you are what?
Under-
That is what I am saying. The learned counsel for the petitioner appearing in WPC 378 of 2017 has submitted that the connected review petition, namely review petition number 77 of 2023, is required to be decided prior to these the other writ petitions, other connected writ petitions. Full stop. Accordingly, list these matters before the appropriate bench taking up the review petition. When do you want it? On? As per other writ petitions before the appropriate bench.
Allow me to review.
Along with the review petition. Okay. We're not fixing a date because we do not know the.
I'm the clear.
My
Yes.
lord, I'm praying for listing on contempt case, your lordship. This is for-
Contempt case
My lord, for orders, your lordship.
for orders.
First week of February, my lord.
Notice was issued.
My lord,
Was notice issued?
my lord, notice.
Steps have been taken.
My lord.
Have you seen the service report?
My lord, since long this is not listed, your lordship.
Kindly find out the service report. If required, get it listed before the law azima. Once the service is complete, we can take up the matter for some action to be done here. Otherwise, we'll take up the matter, say, list it before the law azima for service report. What benefit? Get it listed before the law azima. Find out today.
My lord.
If the service report is there, mention it tomorrow, we'll allow it for the next week. Okay?
Obliged.
Yes.
I think for 40 that
Mm.
we produced record,
Mm.
but records have not been received, so I pray for 2 weeks' time. Item number 40, we have taken the conflict from the other side.
Since when have the records not been produced? When was the last order requiring your records to be produced?
Uh,
Yes. Item 40, you say.
11/11/50.
Learned counsel appearing for the respondent has submitted, for the respondent, BTC has submitted that the records called for are yet awaited. With the consent of the learned counsel for the petitioner, list this matter again on we'll have it on 16th.
16. I am for the petitioner.
16th of February. Mr. So-and-so, learned counsel appears for the petitions.
Yeah,
Yes.
please, your lordship. I beg to.
Prayer, my lord, with regard to item number 16, my lord.
1-6. Yes.
We are awaiting instruction in this matter, my lord.
2018, not without the matter being taken up. We'll take up the matter. We'll see what kind of an instruction you need. Only then.
Matter was pending for service, completion of service.
Hmm.
till 20.
We'll see whether those persons are required to be served or not. If it is a simple question where the department is supposed to do something, why should we get everybody to before the court? Let the matter reach 2018, nothing before 2022, no matter will be adjourned without taking up the file.
Yep.
Yes, sir.
I beg to mention item 15 and 17. 17,
Hmm.
we have taken the consent. And 15 will file additional affidavit, Your Lordship.
No, I said before 22, nothing will be taken, nothing, no orders, no adjournment without taking up the file. We'll take up the file, we'll see what is the matter.
15, sir, will file additional affidavit.
So be it, we'll see what kind of an additional affidavit.
Oblige, Your Lordship.
From 2019 now, we'll have to see.
Your
Yes,
Lordship, item 41 also, sir.
41,
It
yes.
was listed, you are an advocate in that, Your Lordship, so
Mm-hmm.
you are advocate in that petition, so it was in your bench, so it may be adjourned to
It's a review petition.
item 41, yeah.
I was appearing in the matter.
You were advocate at that time.
I appeared in the matter.
Yeah, yes.
List this matter
17
before any
consent
other court
then it
without
will
me.
not-
Huh?
Consent law has a- Is for 7.
Response 7, Your Lordship.
Oblige, Your Lordship.
Yes,
My lord, item number 32.
32.
Sent for taking.
Yes, Mr. Sharma.
This week, madam.
This week itself, yes. When will you have it? On Friday? Send for waiting.
Going to be provincial. Yeah. Next week, any day. Next week.
Next week, okay. Then we'll have it on 10th. On 10th, but have the affidavit filed so that something can be done. The learned counsel appearing for the Elementary Education Department has submitted that the affidavit has been sent for vetting and will be filed within the week. At the prayer, at his prayer, lists this matter again on 10th of February 2026, by which time the department shall ensure that the affidavit has been filed. Full stop. Mr. N. Sharma, learned counsel appearing for the petitioner, has submitted that there is an urgency in the matter. The counsel for the respondents should take note of the same. List accordingly.
All right.
Yes.
On special right, mediation, one.
May I please, Your Lord?
Yes.
My lord, in this case, my lord, actually J.K. Parajoli was conducting advocate, my lord. He expired January 25. So I have no contact with the clients. Though I have written one letter to the petitioner number 1, my lord, I have received no response. So may I pay the, my lord,
Just one thing, this is Brajraj Gautam. What was this matter about? This is to be sent to the mediation. The court has listed it for that.
yes, my lord. May I pray that matter may be sent for mediation in the meantime, my lord, matter may be fixed after 3 weeks, my lord. In the meantime, let me try again, my lord.
But
Please-
what we have noticed is from the synopsis,
Yes. I have no instruction.
non-consideration of the past services for computation of the pensionary
yes,
benefits. What,
yes,
what would the mediation do in this?
That is fine.
I think which group, Purnima Hore,
Mediation
Purnima
is-
Hore matter had decided some of the matters.
Good.
Regularization orders in 2020, in
Yes.
2003.
Yes. Yes.
Directed the respondents authorities to count the pensionary benefit of the writ petitioners from the past services.
Yes.
Similarly situated, they want to have it. Similar writ petitions have been dismissed. Writ
Dismiss.
appeal is pending.
Oh,
Writ appeal is pending. 29th of January. You have your attempt to contact the petitioners.
yes, my lord.
We'll have it listed in the on 9th of February.
Let it be after 15, but at least 3 weeks time may be given, my lord.
We'll have it on the 16th of
Yes.
February,
No, after 18th, any day, my lord.
on 19th of February, on 19th of February, by that time,
I will
find
try.
out if mediation will help or নাকি এটা
Mediation may not
mediation
help.
পঠিয়াবই লাগিব নেকি? হ্যাঁ? Covered case হয়। Mediation পঠিয়াই কব কৰিব কি? Okay, we'll send it to the mediation. We'll have it
Okay.
again listed on the 16th. By
Yes,
that time,
yes.
find out. Mr. So-and-so learned counsel is appearing, is present for the petitioners. Mr. So-and-so is appearing for the respondent education department. List this matter again on 16th of February 2026, on 19th of February 2026. Mediation ওখানে date to fix করে নিবি মই, হ্যাঁ? List this matter before the mediation center on. We'll have it listed on the 6th of February for mediation.
Okay.
Full stop. List again on the 18th of February along with the mediation report. If none appears, we'll take it up.
Before the mediator on 6th,
6th.
deep level.
Item two.
I forgot. Oh, 6th and 18th, you did. Oh, it will 18 on আহিব ন? Yes.
May it please the Lordship, let the matter be referred for mediation.
Yeah, my lord.
Huh. Which district? Should I send it for mediation or should I say not by me? I remember the name. List this matter before any other bench without me. Mediation মই একোৱে order pass কৰিব নোৱাৰো।
Hey, please, your Lordship.
Hmm.
Lordship, we haven't been able to contact the petitioner directly, Lordship, because we do not have the phone number at present, Lordship. So we have communicated via post, Lordship, and at present we are awaiting instructions, Lordship.
We'll fix it for mediation on the 6th.
Lordship.
If none appears there, then the matter will come back here. Usharani Deka, I remember this name again.
Between mother-in-law and daughter-in-law regarding pension.
Compassionate family pension.
Husband was a teacher.
Yes.
List this before any other bench without me again. If I remember correctly. Just let me see for once.
I don't think. Madam.
Hmm? I think I have given advice in this. Yes. I have advised in this. Before any other bench without me.
Stand to mediation, madam, may do it. In the event, if anybody appears, then we can see. At least that order maybe today.
Learned counsels appearing for the parties have submitted that the matter may be referred to mediation. Accordingly, list the matter on for mediation on the 6th of February 2026 before the mediation center where the parties shall appear. List the matter again on 20th of February with the mediation report. No, they want to send it to mediation. This তারিখে দিছো না মোৰ বেঞ্চত বুলি মই ফিক্স কৰা নাই মোৰ বেঞ্চত কি আহিব mediation will sort কৰি it will not be proper for me to pass any orders in this. That's not proper. Let us not do it. List this matter before any other bench without me. Thank you.
May I please, your lordship?
Yes.
Standing lordship, Mr. F. Islam is like another court lordship.
Can it be taken up for mediation or not? It is a simple order.
Go for mediation, then lordship.
Share of family pension.
So why don't you go before the mediation center? List this matter before with the consent of both the parties, list this matter before the mediation center on the 6th of February 2026. List this matter again on 20th of February with the mediation report. है ना? Will mediation help here?
Otherwise, well, the system has been done.
No, the issue is otherwise. You are receiving the petitioner is receiving compassionate family pension. And her claim is that that is only in lieu of the compassionate appointment scheme. That scheme will not override the usual pension that the family had to get, the family pension that the family has to get. So,
Page 14, this is the petition order.
no, if you read the order dated 7/2/2022, that is the whole issue.
Yes.
See, family pension is one part. Under the pension rules, family pension is one part. Then you had introduced the compassionate compassionate appointment scheme. Now, a person with compassionate appointment will also be entitled to the family pension under the pension rules. Once a person is appointed, the son is appointed on compassionate appointment. The mother gets the family pension under the pension rules. This compassionate appointment was not over and above, the family pension, is it not?
I think here, the petitioner's husband, he died on 28/6/2019.
True.
After that, 2017 scheme was adopted.
Yes.
So therefore, she is entitled for the salary as it was entitled by this.
Let us say it again. Let us understand again. A person dies in service. The wife gets the family pension. In the meantime, the son applies for compassionate appointment. He gets a compassionate appointment. Does the pension to the wife stop? No. Now, instead of a compassionate appointment, you say we will give you the compassionate family pension. Can that scheme override what is already given in the Assam pension rules, where the wife would be entitled to the regular family pension? Here the claim is, although I am having compassionate family pension, I am also entitled to the family pension under the Assam pension rules. Give me that. Why not? How can a scheme override a rule? Either the scheme has to say that this scheme will not be applicable to persons who are getting regular family pension, or the rule has to change, saying that anybody taking compassionate family pension, this will not apply, or you have to show us something in the Assam pension rules which says that if any other pension is being paid, this will not apply. Something has to come up. The finance was made a party. Is it reflected in the cause list? This is item 5. None appears for the petitioner on call. Mr. B. Kaushik, learned counsel, appears for the Education Department. By the order dated 7/2/2022, the petitioner was directed to implead the Finance Department of the Government of Assam as respondent number 6. Full stop. The records do not reflect that any steps have been taken by the petitioner to implead the Finance Department as a respondent in the present petition. Full stop. Accordingly, list this matter again on 20th of February 2026, reflecting the name of the standing counsel Finance Department, comma, a full stop. The petitioner in the meantime would be at liberty to file an amended post title incorporating the finance department as the respondent number 6 in the petition, full stop. In the absence of representation on the next date fixed, comma, appropriate orders would follow. This is a question which will require some attention. Otherwise, two pensions would come, one under a scheme, one under a rule. So we'll need the finance to show us whether that can be done. Otherwise, huge financial burden. Not before me.
Item 6.
Item number 6, not before me.
But 6 and 7 are a similar matter.
Could be, on 2022, myself had taken time for
Yes,
filing.
the specifically instruction is there.
Item number 6 and 7. List this matter before any other bench without me.
But 7, your lordship can interfere because there is no specific appearance on behalf of the respondent in 7. 7.
I may have a set mind frame. Yes.
But this is the matter is similar regarding the promotion to the post of the headmaster and the superintendent.
Which one? Item
7.
6 and 7, both it was for mediation. But still, since we had appeared in the matter, I have not passed. We have just simply said list this matter before any other bench without me. You can have it listed tomorrow, day after, anywhere, anytime. Get it referred to mediation if required.
Yes. Well,
May I please, Lord?
Yes.
Yes. This matter pertains to non-receipt of pensionary benefits, Lord. What has happened, Lordship, in the year 1989, he was initially appointed as a grade 4 employee in a high secondary school. Thereafter, Lordship, after serving for around 11 years.
Mr. Ganguly, two things. One, this has come up for referring to mediation, if I'm not wrong. Now, if you say that this matter can be sorted out in mediation, there is a possibility. We'll refer it to mediation. If you make a submission that if it will not be of any use, then we'll say that there is a submission and therefore let the matter be decided.
This person is without any salary since 2021, Lordship. And there was a direction by the coordinate bench of this honorable court that provisional pension is to be paid from the 1st of April 2022. That also he is yet
We don't have a contempt before us.
No, contempt is already closed, Lordship. Contempt is, we may try it.
If you want to have it before the mediation, we can simply send it to mediation. That is it. But both the learned counsel for the parties, they have submitted that the matter may be sent for mediation. List this matter before the mediation center on 9th of notice of consideration on the 6th of February 2026. Or on 6th of February 2026, where on which date both the parties shall appear before the mediation center to attempt a conciliation.
Item 9 to 10.
That data, realistic on data list this matter again on 20th of February along with the mediation report.
And in this case, this is a old pension scheme, my lord. On 29th of January, it is fixed in the writ appeal for hearing. So no order is necessary at this time. Let the matter be listed in the month of February, last part of the February.
Ms. K. Devi, learned counsel for the petitioner, has submitted that the matter, the writ appeal governing the issue, covering the issue raised hearing is slated to be listed on the 29th of January. 2026, full stop. Accordingly, list this matter again on the 13th of February 2026.
12 also, my lord, similar.
12 also, same order. 12 to same.
Oblige.
You want me to say? No, 8 commandments. 11. Yes. Can it be sent to mediation, sir?
Yes, my lord, it can be sent only, my lord, I have some problem with that date, my lord.
Ah.
Because 6th I'll be not here, my lord, 6th February. There's the flaw. Otherwise, I'm
5th? 5th?
5th, 6th, 7th, because some family.
Till when is the mediation?
Date, I don't know, I'm not aware about the date.
Learned counsels appearing for the contesting parties have submitted that the matter can be referred to
Yes.
mediation.
Yes.
Accordingly, this is matter for mediation on 11th of February 2026
No,
at the mediation center, so that on which the learned counsel, the learned party shall appear and attempt a conciliation. Full stop. This is matter again on the 20th of February 2026,
give me all.
along with the mediation report. Ah. Yes, sir.
May please your lordship. Here in this case, the petitioner was appointed in the year 1993. He was subsequently sent for junior basic training, completed the junior basic training. Then he was given time scale. Thereafter, salary was stopped. He filed a petition along with others for claiming salary. That was disposed of with the direction to consider as per the Sudhanda Mohan case. Then there was a verification of appointment. And he participated as per the affidavit of the respondent. Number 1, he participated. And there was an offer, subsequent offer for fresh appointment as per their affidavit. But problem is that my client is to file a reply, a rejoinder affidavit. My client is not responding, my lord. I'm the report coming that he is not keeping well.
The difficulty is there is an order of 11/5/2022.
Yes,
That
madam.
bunch matter,
Madam.
that whole bunch that was being listed
Yes,
together,
madam.
I was appearing in that.
My lord.
So this has to go. List this matter before any other bench without me.
Madam.
The salary matters, no?
Salary matter.
After some time, go. That's just okay, sir.
68. 168.
Item 15.
15?
15, 1.
Yes? You want me to take it up?
No, adjournment, sir.
15?
15, 1.
Why the adjournment?
We'll file additional affidavit, your lordship.
What was the matter about?
It is increment for B.Ed. One petitioner has not submitted his B.Ed certificate. He has completed in 2005. So we'll file additional affidavit regarding that. Vinay Chakraborty,
B.Ed certificate to whom?
to the court regarding his
We'll look into that. Yes, who's appearing for the department in this? Huh? Who's appearing for the education department? BTC will not be able to bring it on. Mr. Sharma, you will appear in this matter? Now, we want your presence here. We'll allow you that. We'll allow you that. We are not disposing it off. We'll allow you. This is a matter where this is a matter of advance increment because the petitioners have acquired the B.Ed degree.
before 2000.
Now, if you come to that order passed in the writ appeal WA 336 of 2017, is it there with it? Durjaipal order you have?
Yes, sir. 41 candidates are there that they have been
In Durjaipal.
in that petition.
Now see, from what we have, what we would require before this court, huh? Mr. Sharma, take a note of this. In Durjaipal? Yes. Now, why was that done? Any idea? Why was it required only for 41 candidates? And why was the question of law kept open? This Durjaipal order came out of an order passed by this court This was disposed of on 16 to 2016, huh? Present appeal has been preferred against the order dated 16 to 2016, is it? Now, just prior to this, sometime in the month of September or October of the previous year, another order was passed by coordinate bench. Justice, my Lord Justice Pathak, if I'm not wrong,
Yes.
where the office memorandum was upheld.
Yes.
And in Durjoy Paul's case, the office memorandum was set aside after a few months. Both had their own different reasonings. Okay. Thereafter, Durjoy Paul, the state went up in appeal in Durjoy Paul. State had already given the benefits. Court said since the benefits are given, we are not interfering in any manner. Done? On the next date, kindly be prepared with this. That order which had upheld the office memorandum and the order which had set aside the office memorandum. If these are the two orders,
Yes.
which order was required to be followed? This aspect has not been discussed in Durjoy Paul. Would the department or would the petitioners require a clarification as regarding the applicability of the two orders? Office memorandum in one is upheld. I forget the name of that case.
Yes.
It was upheld. Yes, you don't need to give a increment. Then,
Those were,
And there was probably not silence.
those were completed in 2012. Before 2012, they will get.
ultimately it boiled down to those who got,
Mm.
those who acquired the B.Ed degree prior to 12 will get it. Sorry, those who were recruited prior to 12 without the B.Ed,
Mm.
they would get it. Later ones would not.
Oh, yes.
Something like that.
Yes, that's.
But those two orders have not been discussed anywhere. The one upholding the office memorandum and the one setting aside the office memorandum. Find out if that needs a decision. Mr. So-and-so letter counsel has appeared for the petitioners and he praised an opportunity to file an additional affidavit to bring on record the B.Ed certificate
Regarding
of one
petitioner
of,
number 11, Binoy Chakraborty.
of one of the petitioners,
Mm-mm.
which was inadvertently not annexed to the writ petition, full stop. Learned counsel appearing for the department has prayed for a short accommodation to place on record the, to place before this court the present legal position regarding the benefit of, regarding granting of the benefit of an advance increment on acquiring the qualification of B.Ed. Full stop. List this matter again on, yes, give us a date.
After 3 weeks. 19th of February.
19th of February 2026, on which day, by which date the petitioners shall file their affidavit, additional affidavit as proposed, and Mr. U. Sharma, learned standing counsel, Secondary Education Department shall also have his submissions prepared.
1960.
Oblige.
Yes.
May please, Your Honor. In this writ petition, my lord, the petitioner has challenged the impugned order dated 16/7/2013, my lord, page 36, my lord. Whereby the
In
provincial
case, this is a request, in case anybody feels that, so if you feel that I had appeared in the matter, kindly let us know beforehand.
My lord,
If I have taken up the matter before, kindly let us know if I had appeared as advocate in the matter.
I cannot, my lord, follow, my lord.
Let us know if we have already appeared in the matter at some earlier point
Oh, my
of
lord,
time.
my lord, yes.
Because we may not
Yes,
remember.
maybe.
Yes, which page we are talking of? Page?
Page 36, my lord, is the
30.
impugned order, my lord. Impugned order, my lord. There has been challenge in this present petitions, my lord. Sorry, my lord, page 38, my lord.
Yes.
The order of provincialization benefit granted to Sri Vishnu Deka, Assistant Teacher, Sonvana, under the communicated by Director letter number so and so is hereby withdrawn until further order. This is issued in connection with the Honorable Court's case in WBC number so and so, filed by so and so. My lord, before that, my lord, I will place the facts, my lord. The my lord, respondent number 10, my lord, was initially, my lord, third assistant teachers of the, my lord, Sonpani Sarvajanin LP schools, my lord. And lordship will find page 17, my lord. 17, my lord. The resolution number, my lord, 1. Page 17, my lord. Lordship got it, my lord. The third assistant teacher, Sitaranjan Sharma, that is the, my lord, respondent number 10, my lord, is very irregular and misbehaves with the student since this date of his joining in the school. Since he has remained absent from the school for last 1 year, today's meeting authorized the headmaster cum secretary of the school to issue show cause notice to Sri Sitaranjan Sharma to explain his reason of absence from the school, my lord. Now, lordship will find Annexure B, page 21. My lord, fourth paragraph. my
Did
lord.
he approach the educational tribunal?
Yes, my lord.
What happened to it?
My lord, that lordship will find in my reply affidavit. Page, my lord, 69.
Who appears for the private respondent?
My lord, name has shown, my lord.
Was there any representation?
Affidavit also, my lord, filed, my lord. Page 69, my lord.
What does it say?
Order, my lord, page 70. There has been, my lord, dismissed for, my lord, default. That order is, my lord, dated 15/6/2023, my lord. So the interim order, my lord, has been merged with the final order passed by this honorable court, my lord. So the present impugned order has been passed based on the, my lord, impugned order, my lord. Sorry, my lord, interim order.
Where is the interim order? Can you show?
Yes, that lordship will find. At page 36, operative portion, page 37.
Page
37. This requisition has been filed by the respondent number 10. Last part, my lord. Now, my lord, the final order that based on the, my lord, interim order, my lord, the page 38 impugned order has been passed, withdrawing my lord, provincialization benefits, my lord. Now, lordship will find the final order starts at page 39. Operative portion, lordship will find page 42. My lord, second paragraph. Line starts, my lord, in that view of the matter, my lord.
Okay. Yes, who appears for
And
the
my lord,
petition?
last line, my lord, the interim order passed earlier by this court on 16/7/2013, then marked with this order. So my lord, that interim order, since it has been merged with the final order, my lord, it has no effect, my lord. Because the liberty has been granted to the, my lord, petitioner to approach before the tribunal, my lord. And he has approached before the tribunal, my lord. And tribunal's, my lord, case has been, my lord, dismissed for default.
Yes, madam.
And,
Tell us on the point of law.
Regarding my provincialization, my approval has come from the department, madam, to the citizen, from the education.
Provincialization order, I have annexed, my lord.
we expected some assistance from you on the point of law. There was a writ petition which stayed the provincialization. Writ petition was disposed of saying that the petitioner will be at liberty to approach the tribunal. Tribunal has dismissed the matter. What is the position today now?
Lordship, since I have no instruction regarding this today.
You need instructions on submissions of law also. Yes, who appears for the educational department?
Elementary.
Yes, sir, throw some light on this. Anybody appearing for the private respondent? You are? Who is respondent number?
Headmaster. Headmaster.
Yes, Mr. Tell us,
I have to take instruction.
what instructions? Do you have a copy of the writ petition? Do you have a copy of the writ petition? Please, now take up page number. He was reading page number 37. Page number 37. Last lines. Done? In the interim, it was state. Page 38. Your order? What does it say? Withdrawn. How could you withdraw it? Done? He did not take up that matter before the honorable court? That point of time? Now this matter is disposed of, page 42. Page 42. Last page 42, second paragraph and the last paragraph. 16.
The petition with the project response number 11 and on appraisal of the original reports pertaining to the
No, we don't need that paragraph, just the paragraph above that. In that view of the matter, writ petition stands disposed of with the direction to the
petitioner
approach the appropriate educational tribunal. Last line. Interim order stands merged. So the writ petition was effectively not entertained, allowing him to go before the educational tribunal. Writ petition not being entertained, the interim order is now merged in a writ petition, in an order which did not entertain the writ petition. Now he approaches the tribunal. Page 70. Dismissed. None appears for the respondent number 10 on call. Yes, heard Mr. Ashrama Leonard comes. Yes, you want the order now at 2 o'clock. The order withdrawing the provincialization was not correct. You could have kept it in abeyance. Pendency of a litigation, interim order not to give him the benefit of provincialization. Keep it in abeyance. Withdrawal is wrong. Let us say it is correct. They go to the tribunal. Dismissed. So the order of provincialization revives. At 2 or now? At 2, huh? At tomorrow. At the request of the learned council appearing for the respondents, list this matter again. Tomorrow. As a part heard matter. Find out now that you had withdrawn it. And he had challenged it at that point of time itself. That withdrawal, even before the other person approached the tribunal person, perhaps. So what this will be continuity of service, and if he has not worked, he was not allowed to work because of your illegal order, which may entail. Yes.
Obligement.
Item 17.
List this matter
After 2 weeks.
without me.
Item 18 to 20.
18 to? Higher education. Yes, madam. You are for the UGC. Item number 20. Okay. Document 18 to 20, na?
May I please, Lord?
Yes, sir.
My Lord, petitioner before your Lordship in item number 18 was initially appointed on 23/8/1999. And subsequently, after office memorandum and due to non-availability of permanent vacancy, she was not regularized, and finally passed an order whereby the petitioner was appointed against a sanctioned vacant post. Annexure 16, page 43.
What is page 24?
Page 43, Annexure 16.
Just a minute. Page 24 is you were appointed as a lecturer. Then
24 is the initial appointment. After
non-sanctioned
following due process.
in a
against
non-sanctioned post.
Yes.
Then
She continued his service, and in between she pursued her PhD degree from Singhani University, and finally she was appointed by issuing fresh appointment letter, that is page 43, wherein some conditions are inserted. As per condition 2, the incumbent concerned will be required to qualify in NET/SLATE PhD, wherein at the time of her engagement, she was acquired her PhD degree. That is also already annexed with the writ petition. In this appointment letter, my Lord, the eligibility as per UGC written as nil. That is in table. And subsequently, petitioner approached the authority by filing representation and submitting her PhD certificate. That is page 46, submission of documents of PhD degree. But due to non-consideration of her PhD degree, she again filed a representation before the respondent number 2, that is page 48, annexure 19. Elaborately, entire statement, entire story is stated in that representation. And on that representation, the respondent number 2 asked the principal of the said college, asking the particulars of the incumbent. And finally, the principal of the Choropathar College submitted the particulars and necessary documents as asked for by the Director of Higher Education, that is Annexure 21, page 56. Here, my lord, in the second paragraph,
Yes.
it is clearly stated, the incumbent obtained PhD from Singhania University under registration number such and such on 31/12/2013, and Dr. Orsona Gogoi's pay was fixed as rupees such and such. Post creation under this height dated 25/4/2018, the college forwarded a letter to the DIC Assam for regularization.
At this stage, sir, you are not getting the UGC scale of
Yes,
pay.
that is the,
Your service is not being disturbed for the time
yes,
being.
my lord.
You just need the UGC scale of
Yes,
pay.
yes, my lord.
Stand of the department is that your PhD is not recognized and therefore we
I
do
am-
not want to give you the UGC scale of pay.
Yes, my lord.
That is the whole
That is
case.
that is the whole case. And this issue already settled by Punjab and Haryana High Court.
Why not the Guwahati High Court? Why is the Guwahati High Court not settled
My
this
lord,
issue?
Punjab and Haryana and Bombay also, my lord, but that is not as per my little knowledge. I think that particular issue has not been issued.
Whether the PhD of Singhania University will be
It is said that in one case that if distance mode, that is not considered. But petitioners concerned, they pursued their PhD in regular mode. And this certificate is also I annexed in my affidavit.
Yes, you appears for UGC. You have filed your affidavit, madam. In item 18, you are appearing. Yes. You are appearing in that matter also. Item
Yes, my
19 is
lord.
also
Yes.
yours. Item 19.
Number 127.
Thank you. 20, हाँ, हाँ, page number 137.
So the non-secretary post of lecturer in Zagreb College, right, order dated 2001. He was awarded degree of PhD 1911 by Singhania University, Rajasthan, UGC.
So you say that it is okay. That's a good PhD.
Lodge.
She was awarded the degree of PhD by Singhania University as per UGC Regulation 2009. Oh, as per the petitioner, huh? Then?
According to the petition, the FC completed in 1987 and was subsequently appointed a lecturer by order dated.
Yes, that is
This one.
I think it is not.
130.
Seven. Yes.
Was the Singhania University made a party to this petition? No.
No, my lord.
So now your stand in item 19 is that he did not pursue the PhD properly because he was a full-time lecturer here and could not have pursued the PhD in the regular mode. Can you question it? Can you question it? Is what we are trying to find out. Some university gives him a degree saying that he has attended classes, he has done it in this manner, he has done it in that manner. Sitting here, can you question it? Or sitting in Delhi, can you question it? What was the mode? I think there are two judgments. Hazarika, Mukul Hazarika, or Ranjit Hazarika. So you are not questioning the PhD certificate. You are questioning the mode in which he has done it. Yes, what do you have to show that you had actually pursued the course there?
Yes, my lord.
Do you have any leave certificate, anything?
Yes, my lord.
Where is the leave certificate? Huh?
My lord, I am giving.
Hmm. One case has been decided by this High Court regarding a B.Ed degree where the allegation was that he could not have pursued the B.Ed degree while working as a teacher in the particular school. This court has held that once the certificate issuing authority grants the certificate, who are you to question whether he attended, he did not attend? How can you? Then there was another case of this High Court, some Hazarika, where again this the particular person serving in this High Court had taken a law degree from Nagaland. A disciplinary proceeding was initiated against him. This court said no. You cannot, division bench of this court has said no, you cannot question the mode in which he has taken. Once he has the certificate, it is a certificate. He went there, he did not go there, he went there. How are you? Who are you to question it? The university did not question it. Either you have to say that all PhDs given by Singhania University are not good in law. Whether he went there or he did not go there, you question it. Yes, sir, you are prepared with the judgment.
My lord, that is, my lord, relating to NOC for pursuing PhD. That the page number, my lord, 36, annexer 9 series. No objection certificate.
To do what?
My
To
lord,
pursue PhD.
yes, my lord.
How does it show that you went there? That you were granted the leave?
Yes, my
That you
lord.
are permitted to go? Where is it?
Yes, my lord.
This is the NOC. If you pursue PhD somewhere, we don't have a problem.
Yes, my lord. And
That will not help you. Yes. Yes, madam, you have those judgments. What is your stand? You are appearing in another matter for the UGC. That he could not have pursued the PhD while teaching here. Justice Nayar's order, recent one. B.Ed degree, Justice Nayar. The other one is, well, what is that, Mr. Kaushik, you remember that Hazarika? It's Guwahati High Court Division Bench. The law degree was questioned. He was serving here as a registrar or a deputy registrar, and he produced a certificate that I am a law degree holder during his service period from the Nagaland University. The disciplinary proceeding was initiated against him. This court came to a finding. I don't know which. Then this court, the allegation against him was that while you were serving here, how could you pursue a course in Nagaland? You were here. Division bench held no. Once the university says he has pursued it is up to this court to have up to the administrative side to have marked him absent, taken down his leave or not leave. Question it then and there. Now can you come back to question it whether he attended classes then or then? And if that is the stand and this is the only who appears for the hire, yes.
The appointment of research supervisor is also not for the UGC Norms Lordship.
Sorry?
The appointment of the research supervisor Lordship, Dushman Kumar Lordship, in this matter Lordship, because he was a faculty of the institute in Nagaon Lordship, and he has been the Lordship, the research supervisor Lordship. Of the petitioner Lordship, while pursuing the PO.
When the university is granting him a certificate, unless you are questioning the authority of the university to have done so, can you impose it on him is the only question I'm trying to find out answered. Are we able to convey what we are thinking to you? We are not with him, for him, nothing. We just want to have the law before us. He says, I've got a PhD from so-and-so university. You are not saying it's a fake certificate.
We are saying it's a distance.
You are not saying it's a fake certificate.
Yeah.
He is saying it's a question of, I have a certificate PhD. This university has given me this NOC is there. I could have gone and pursued it there. My absence, non-absence, everything done. Even if I went there, let us assume he has gone there from the college during his whatever appointment, unregularized appointment. Did you go there during the unregularized appointment or after regularization? Unregular period. That college allowed him to take salary, that college marked him as present. They did whatever they wanted to. So it was a non-sanctioned post. They did whatever they wanted to. He got that certificate. They showed a continuity in service, leave, study leave, whatever. There's a continuity in service. They propose it, you regularize him. Now, from where are you saying that it's distance mode, or is it a presumption? The person who was a supervisor, he could not have been the supervisor because he was at that point of time in, say, Jabalpur, and he was in Nagpur. Nagaon. Could not be done. Then his PhD degree has to go. His job is not going. You should have taken away his job within the first 2 years. Appointment letter, where is your appointment letter, sir?
My lord,
40. Regularization order.
I'm giving. Page 61, my lord. 25/4/2018.
Your clarificatory affidavit has been filed. Yes, Counsel for UGC. Clarificatory affidavit has been filed.
And regarding, my lord,
Really, huh?
regarding verification of PhD, the Director of Higher Education issued a letter to the Singhani University, and Singhani University also wrote a letter to the director.
Saying
That yes, she pursued her PhD in regular mode. That is a annex, my lord.
So can Recent judgment by this court. You cannot question the degree.
It can be taken till after tomorrow, Lord, sir.
Yes, you can. There was one, some Hazarika matter, Ranjit Hazarika.
My lord, college is there.
Mosumi Soharia is one that was earlier, one that was followed very recently. Very recently, it has been followed. That this question, this part cannot be questioned. And there is one by a division bench of this court with one employee of this high court. That is what I'm. Let us see. Some Hazarika, Ranjit Hazarika. Ranjit Hazarika, if I'm not. Is it? You remember the case? Yes.
Also, in this case, I gave for the principal of Nagina College.
Ah.
Page 70.
In which matter?
In item number 19.
19, yes. What do you
This
say?
one.
What do you say?
Page 75 may kindly. It is mentioned that Dr. Sharma has completed her MPhil in 2009 from Vinayak Mission and completed her PhD from Singhania University, Rajasthan, following UGC regulation so and so. And she took sufficient leave for MPhil and PhD purposes, including MPhil exam. And I forward screening committee has already verified that her PhD degree on 31/1/2019. And I forward committee was formed and they have already verified her PhD degree.
That you have brought on by way of an affidavit?
No, you have not filed affidavit, page 75 of the.
I annexed my writ petition, my lord.
Huh?
I annexed, my lord.
The director of higher.
Mohendra,
And also.
Unless you file it by way of an affidavit, how can the department reply?
The cost level was similar, with similar degrees persons are working in various capacities.
And they are being paid the
Yes,
scale.
Dr. Asmat Ali, Dr. Pankaj Kolta, Jyoti Kamal Hospital with the same degree, they are working. So why the department has taken a student to choose policy?
Pick and choose policy. Yes, pick and choose policy.
Other persons are working. The same degree.
I'm not being able to trace out the judgment. Yes, this, what's Mosumi Saharia? What does it say?
A degree offered by a university cannot be nullified by a third party.
The university offers the degree exercise power under section 24 of the University Grants Council by 1956 and taking over the principle of the general laws lab. It is only the university who can declare the things to something in the law on their authority. No other third party can be understood to have any authority not to accept the degree offered by a university in exercise of the powers of the
Now there'll be one exception to this. Say the B.Ed degree is given by a university in a distance mode. The university did not have the capacity to do so by an or even by an unrecognized institute by the, let us say by this teacher's education, that B.Ed degree. It requires the NCT approval. Now, even if the university has the authority to give a degree, that degree will be an unrecognized degree because the institute was not recognized by the NCT. In that case, the degree does not fail. The degree remains unrecognized. The degree yet is there. But it will not be taken into account for any purpose whatsoever. It is just a degree which, it is like getting a BSc or a BAcom from a private, if you come to my home and tomorrow I give you a BSc certificate, it will have the same value. No recognition now. But you cannot challenge the degree itself. You know, if you take a stand that any PhD degree given by the Singhania University is not to be recognized by anybody. Singhania and two other universities had faced the courts regarding their degrees and their PhD. If that line of argument comes in, it's a different issue. But here you are trying to question the degree itself.
And recently, my lord, UGC issued a notice.
The validity of a degree? and you're accepting a degree are two very different things. You cannot refuse the degree. You may not recognize it. If you take a stand that the Singhani University has wrongly given that, was not competent to give that PhD. Very well. Yes. But Singhania has given it. You are not questioning the authority of the Singhania University. You are saying he got it in a wrong mode. He cheated. Basically, you are saying he's cheated. Once you have a matriculation pass certificate, a higher secondary pass certificate, you might have cheated, you might have not. How does it matter? You have the certificate, that's what matters. Yes. What does it say? For the college authority, you also want to give the salary. Ah. Hmm. Yes, Mr. Gogoi, we are being disturbed by the judgment in Mosumi Shaharia, which says that you cannot question the degree once it has been taken. Yes, sir.
Here also, whether that degree can be treated as a lordship for that purpose or not.
That is what Mosumi Shaharia says.
Division bench judgment also there.
Yes, what does it say?
Regarding also research guide, but our specific instruction is lordship, the research guide is not from the particular university.
Hmm.
Then when research guide is from the particular university, that degree cannot be accepted. I will press my case.
Tuesday, no, Tuesday. Can we have it at 2 if you are free? Huh?
Then was it Thursday?
Thursday?
My lord,
Thursday? You are for the college?
my lord, a similar matter. my
You have filed your affidavit. Oh, he was attending college at that period. Okay.
On Thursday at 2 p.m. also.
Thursday at 2?
My lord,
This matter has
My
been
lord.
heard at length.
my lord, I am in some difficulty, my lord, in Thursday, my lord. After 5th, my lord, 10th of February, my lord.
10th of February at 2 p.m. in lordship.
10th of February, 2 p.m.
2 p.m. lordship.
My lord.
10th, you are here. Your affidavit is there on record. Have someone place the records before us on 12th. 12th? This matter has been heard at length for some time. Place this matter on the 12th at the request of the council for the parties. Full stop. The councils are requested to be prepared for disposal of the matter on that day. We'll try to dispose it of. What impression we had was, unless the PhD is taken away.
I rely on judgment, my lord,
Huh?
Punjab and Haryana.
Mosumi Saharia says once the degree is given and not withdrawn, it continues to give the benefit. There was one Hazarika division bench judgment, some Hazarika.
4 judgment lordship.
Hmm.
1 judgment from our division bench and 3 judgments from Honorable Kolkata High Court, Kerala High Court, and Rajasthan High Court. Exactly same issue. Exactly similar issue. Then that is court.
Yes, sir. On
My lord.
12th, please be prepared.
10 or 12, my lord.
12th.
My lord.
At 2 p.m. lordship.
We'll take it up at 2 p.m. that day.
Our
Has been heard at length, Kisana. List again on 12th of February as part of.
Item 21 to 25.
In this case, my lord, I am appearing for in item number 21, 22, and 24, my lord. My lord.
Yes, sir.
My lord, at 21, 22, and 24, I am appearing, my lord. Lordship regarding provincialization, my lord. Is that
Anybody appearing on, you are appearing for 21?
22 and 24, my lord.
Mr. So-and-so Learned Counsel appears for 20,
1, 22, and 24.
24. Who appears for 23?
My lord, in another case, my lord,
Yes, what is this?
M. Datta was appearing.
What is this?
Prop teacher from provincialization under.
Ah.
Here, last one one, we are going to file the affidavit. It was signed, your lordship will be filing due course, your lordship. And Mukul Sharma, your lordship already, Mukul Chandra Sharma affidavit already filed.
Mm.
And another, your lordship,
But,
it is Suladhara. 22, pertaining to item 22, we can file our affidavit. Only
Every-
pertaining to item 21 and
You are seeking provincialization under the 2000?
24,
13,
file our affidavit.
11 Act.
11 Act. And by virtue of my lord, Dilip Das judgment.
Huh?
Dilip Das judgment. That's
What is Dilip
2018,
Das
my lord.
judgment? Show us. What is Dilip Das?
My lord, page 17 is the order, my lord.
17.
17, my lord.
Ah. Have you gone through Punabati Brahma? Have you gone through?
Oh.
Punabati Brahma, you have not gone through. Give him a copy, add 2. Punabati Brahma.
Well, other case they want to file,
Huh?
in other 2 cases, they want to file affidavit, let it posted next.
No affidavit, whether the law allows you or not. Why keep someone hanging like this?
No, my lord,
Division bench has said, if you were not provincialized until that point of time, you had not drawn your salaries, if there was no notification, then any consideration has to be done under the 2017 Act, not under the 11 Act.
in that case, my lord,
So sorry ho jayega, huh?
item number 21, my lord,
Hmm.
maybe disposed in the light that my case may be considered under 17 Act, my 17 Act it may be considered.
Have you gone through that judgment at all, Punabati Brahma?
Lordship,
I'm going to give him a copy.
I'll-
No claim for provincialization is to be entertained under the 11 Act.
I don't know, but that's why I'm saying under 17 Act, my lord.
Under the 17 Act, we can do it.
My lord.
But if all these are wheat matters, they'll all go together. Or you want them segregated?
No, my lord, item number 20,
21.
21, 22, and 24, my lord.
Ah.
These 3 matter, my lord. Maybe.
We'll allow the consideration under the 17 Act if
Well.
permissible. Huh?
My lord.
Huh? Heard Mr. So-and-so Learned Counsel appearing for the petitioner also. Heard you, give me the Punabati Brahma judgment if you have it. I have to find it. Kalpana Borua, yes. Kalpana Borua, do you have it? Any one of them?
I have the retaping number, 283, 2019.
Okay, huh?
Punabati number 283, 2019 retaping.
We are yet to reach a stage where we can just listen to the citation and remember what was written there.
I'll get a copy.
Huh?
Take up sometime in the language.
And get us a copy. This is what this division bench has said. Services of the so-and-so. No. We are conscious of the fact that subsequently the Assam so-and-so 2017 was brought into force. In the impugned order passed by the learned single judge, it has been laid down that no writ of mandamus can be issued to approach educational tribunal for consideration of a case as per law in force. No writ of mandamus can be issued in view of the fact that the 2011 Act is no longer in force. The respondents were asked to consider the case of the writ petitioner for provincialization under the Act of 2017 if she is entitled for the same in terms of the provisions of the Act of 17. Since the Act of 2011 was held unconstitutionally invalid, we find no reason to differ with the view.
Given the coordinate bench of the Honorable Court, my lord, by relying on the Suraj Kumar case at sea, my lord, for any purpose under 2011 Act, no orders can be passed.
No orders.
My lord, 17, well, under 17.
Heard Mr. Swain, Learned Counsel. This is for item number 21, 22, and 24. Heard Mr. Swain, Learned Counsel appearing for the petitioner. Also heard Mr. B. Kaushik, Learned Counsel appearing for the respondent. In this present petition, the petitioner has made the following prayer. Huh? Item number 21. You take from page 15. Prayer to quote kori diba, huh? Just a minute. Where is this order dated 23 to
23, my lord, page 30, type copy 32, my lord.
the order dated 23 to 2022 challenged in this writ petition had recorded as follows. Page 31 or from A to A, huh? Page 31 of that, huh? The learned counsel for the petitioner had submitted that the case of the petitioners being similar to that of Dilip Das
Right.
versus State of Assam,
Right.
WPC number 5233 of 2016, the respondents were under an obligation to have reconsidered the case of provincialization for the petitioner herein under the Act of, under the, what's the full thing?
Assam Venture Education.
Assam Venture Educational Institution Provincial. You'll find it page 18. I have underlined, huh? In blue, huh? Full stop. The learned standing counsel, Mr. B. Kaushik, has submitted that in view of the judgment delivered in the case of Purnavati Brahmo versus State of Assam and others, within bracket writ appeal number 283 of 2019, decided on 13/11/2019. No direction, no mandamus can be issued for consideration of the cases of persons who were left out from the scope of provincialization under the Act of 2011. He has, however, submitted that the aforesaid judgment also upheld the directions for consideration of the cases of the petitioners similarly situated for provincialization under the Assam Education within bracket provincialization of services of teachers 2017 na? Act, if the said petitioners were entitled to be considered under the same. Full stop. He accordingly prays that the writ petition may be disposed of in similar lines. Full stop. The learned counsel for the petitioner has submitted that the petitioners deserve a consideration for provincialization since similarly situated persons had been considered. Full stop. In the next line. In view of the law laid down by the judgment or judgment and order passed in Purnavati Brahmo Supra These writ petitions are closed. Directing the respondent authorities to consider the cases of the petitioners under the Act of 2017 for provincialization if they are entitled for such consideration, full stop. This court observes that while passing the impugned order dated 23/2/2022, the director had not referred to the Act of 2017. Full stop. The cases of the petitioner for provincialization under the Act of 2017 will now be taken up without reference to the earlier order dated 23/2/2022, which did not refer to the Act of 2000 or to the rights of the petitioners under the Act of 2017. It is provided that in case the petitioners it is provided that the petitioners shall be given a hearing at such convenient time by the concerned authorities while considering their cases for provincialization. You go and you
Stipulated period of time, my lord, that is, my lord.
a little difficult on that.
Well,
The petitioners have been agitating their claim from the year 2019. The first provincialization came in 13. You agitated it in 19. Got an order in 2022. Now you want a fixed date on the department.
My lord, earlier also they have approached.
When? Show us. What was the first writ petition? Show
My
us the
lord,
first writ
my
petition.
lord, on 5233 of 16, my lord, she approached before the.
Where is it? Where do we find it?
My lord, synopsis I have stated.
Ah,
WPC 5233 of 16, my lord. So, my lord, third, fourth round of litigation, contempt also filed, my lord.
ah.
This is-
In the synopsis, where do we find it? It is submitted by the learned counsel for the petitioner that the petitioners have been agitating their claim from the year 2013 onwards, full stop. It is expected that the respondents would take up the consideration of the cases of the petitioners in due earnest and shall conclude the same as early as possible, comma, in any case, within an outer limit of 6 months from the date of passing of this order.
The petitioner in WPC 3258 has already got a consideration. It was
Ah.
pending for post-creation.
Then it is also provided that if the case of any of the petitioners have already been taken up for consideration under the Act of 2017, the same shall proceed in accordance with law without being hampered by any observations made in this order.
Obliged.
Anything else?
No.
Yes. Disposed of. Repetition is disposed of. Huh? Eta নাই যোৱা তাৰে 23 নে কোনটো নাই যোৱা?
23 and 24.
I am appearing 22 and 24, my lord.
You are appearing in
22 and 24, my lord.
25.
22 and 24.
21, 22, 21.
You are there in 21 also.
21 also, my lord.
And what about 22 and 24? Same lines?
No, my lord, 22 and 24 I am appearing, same line.
Same line?
Same
That
line.
is what I have said. 23 is not disposed of. 23
No.
23 to Council of scroll ta di diyo. 23 at a scroll di diyo. Huh? 25 to a scroll di diyo. है ना?
Obliged.
23 and 25 will remain.
We are giving a scroll. Let us see if someone turns up.
Obliged.
26.
Yes, sir.
May I please, your lordship, please? My lord, in this case, my lord, my name was reflected as an assistant teacher in the school right from the year 2009, my lord. I was although appointed in the year 2006, my lord. I'll take your lordship to the Dias Code, my lord. Page 21, Annexure 6, my lord.
Page 21.
Yes, my lord.
Pleadings are complete here. Pleadings are complete, sir. Yes.
My name appears at serial number 2, my lord, in the left side, my lord, Irshad Alam.
Page 20.
21, my lord, Annexure 6, my lord,
Serial number 2, yes.
Irshad Alam. And the name of private respondent number 6, my lord, doesn't appear, my lord. He did not appear, my lord. His name was not reflected. And surprisingly, my lord, the district scrutiny committee thereafter, my lord, immediately at page 23, my lord, followed by page 24, my lord. Kindly come to page 24, my lord. My name was dropped, my lord, and at serial number 2, Abdul Aziz in the left side, page 24. and it
Closing
says-
the year.
Yes, his respondent number 6, my lord. His name was forwarded for provincialization of services.
Okay.
And accordingly, my name was dropped, my lord. There is a criteria, my lord, in the act itself, my lord. If I may refer to page 107, my lord, of this particular book, my lord.
আছে নে manual খন? Education manual খন আছে নে? Yes, sir.
Page 107.
107.
Yes. ZB, my lord, the right hand side. Venture Lower Primary School or Venture LP School means a school imparting education up to class 5 and established by the people of the locality prior to 1/1/2006, whose name figure in the Dias Code up to 2009-10, and prior to that, and whereof the service of the teachers have not been provincialized under any act enacted by the state legislature so far. Now, the second line is very important, provided that the Dias Code shall have to be issued on or before 2009-10 and Dias Code issued thereafter shall not be considered for the purpose of provincialization of services of any employee of the institution. In this case, my lord, so far as the, my lord, private respondent number 6 is concerned, my lord, his name was never reflected in the Dias Code of 2009 and 10, my lord.
Prior thereto? Before that, no.
Not even prior to that.
Was there a Dias Code before 910?
In some of the cases, I thought, my lord, in 2008-9 was also there, my lord, in some of the cases. I found that. And in this case, my lord, since my name had appeared, my lord, in the Dias Code of 2009 and 10, the district scrutiny committee, my lord, should have forwarded my name for the purpose of provincialization. And surprisingly, my lord, although there was sufficient number of students, my lord, in the school, in the year 2017 at page 23, my lord, altogether there were 72 numbers of students. Right hand side, my lord, current year 2017 below. As such, my lord, at least 2 teachers posts should have been provincialized, my lord. Including the headmistress and my service, since my name along with the headmistress appeared in the Dias Code as the senior most assistant.
In your place, the respondent number 6 has now been provincialized.
Yes, provincialized. And another shocking part is that this respondent number 6 was also parallelly holding the, I mean, he was working under home guard, my lord, under the Assam Police Department, my lord. Page 29, Annexure 10, my lord. Parallelly. This is a command certificate. It was issued by the concerned authorities, my lord. His name appears in the box, my lord. Home Guard Abdul Aziz. Same person, my lord. Yes, and I have put to challenge the provincialization order, my lord, dated 5/2/2021, page 28, Annexure 9, my lord. That has been put to challenge. So, in my humble submission,
he
my
was
lord,
not there in the school and therefore he could not have been processed.
it should not have been
Now, the
provincialized.
district scrutiny committee, they had,
Prepared a list.
did you take any steps against that list?
Against that list, my lord, I could not take any steps since I did not come to know. I only come to know when the post was provincialized. Subsequently, I collected this particular list, my lord. And immediately this order has been put to challenge, my lord.
When was it passed? When was this order passed?
This order was passed on 5th of February 2021, my lord.
5th of February 2021.
Yes, and it took some days
for me to collect this particular order, my lord.
Hmm.
And immediately, my lord, in the subsequent next year, my lord, 2022, I prefer this writ petition, my lord.
Why the headmistress was not provincialized by the same order, some other different order?
Yes, it
I
is
think
not that.
school-wise it is one order.
There is only one order, my lord. And the post of headmistress, so far as the instruction I have,
Hmm.
that was also not provincialized, although the same was forwarded by the district scrutiny committee. Only one post was provincialized. Surprisingly, this is also very surprising.
Hmm. Okay.
I do not know why.
Yes. Yes, sir. You are the respondent number 6.
The allegation that was made that I had the post of, home guard, etc., I denied. Therefore, there was some inquiry made by the government, and their affidavit shows that there was some correspondence made between the district authority and the home guard authority.
Hmm.
That report is, I think, not on record. And copy was also not given to me. What is the first stand of the government? They have filed affidavit, and their specific case is that, since his name appeared in 2019, and since my name was dropped, therefore I am not eligible. The affidavit filed by me, response number 5, shows that, that my name appeared in the dashboard. Response number 5, in our affidavit, stated that, my name appeared in the dashboard 9.
Where?
Are these issues, once it is questioned, sir?
33.
Hmm. Page
Page 33 of the affidavit.
of
Filed by response number 5. Can you, just one line?
respondent number
5.
5.
Phone number 6, Abdul Aziz, put in bracket, whose name was included in dashboard for the year 2009-2010.
Just a minute, sir. Respondent number
5.
5. Any affidavit? Who's appearing for them? For them?
Typographical mistake.
Ah,
I don't know.
where?
Page 33 of my affidavit.
I'm not finding page 33 of your affidavit.
My lord, para 4 will clarify, my lord. The same
Where is that affidavit on record is what I'm asking you.
para 4 says, my lord, his name was not
Just a
reflected in the
minute,
diary.
sir. Respondent number 2, respondent number 6.
It's a typographical mistake. Para 4 clearly, my lord, reflects that the name was not reflected in the dias code, my lord. The affidavit filed by the my lord.
এখন দিয়কচোন affidavit respondent number 5 or affidavit কোনখন select কৰি দিব। আপুনিও চাই দিব পাৰে। Your stand is that your name was there in the dias code.
Details made by the district scrutiny committee.
Uh-huh.
Details, district scrutiny committee immediate detailed scrutiny. And found me eligible, ultimately they took a decision, made a recommendation. And that was acted
Do you
upon.
have the dias code prior to 2019? Have you brought it on record? The dias code prior to 2019 has it been brought on record whether your name appears? After 2019, doesn't matter. Prior to. Something prior to, sir. You had your time to have your instructions. The matter was filed alleging that your name does not appear prior to 19. So that was required to be replied. Has it been replied?
On the other hand, document can be going to the affidavit filed by the government. Paragraph 6, all the copies now with me, I have got through. Now they are saying it is a typographical mistake. Why you trying not take?
Lord, page 33 of the affidavit, my lord.
I'm sorry.
Yes, in the top.
Second. The bottom side, right? Page 33.
Top.
Yes.
Second line from the bottom there. That, Your Lordship, within bracket, whose name was not included, it was supposed to be was not included, but your Lord, that is topical level, your Lordship, it was included, yes, been written as included. You should have made it fair. There was a factor of mistake.
Okay.
That apart, my Lordship.
So you say that the name did not appear before 910. You say it did not appear before
No, it is
910.
apparently on record also, my lord.
Yes, sir.
So far as my other part of the record is cancelled, my lord. There are number of expansion reports.
Number of?
Right from my lord, 2000.
Does the act require inspection reports to be taken into consideration?
No, that is right. When then my lord, presume that whether he was in service or not,
No,
on the
no.
basis of those inspection report.
So we are beyond presumption.
Inspection report cannot be.
We are beyond presumption, sir.
Cannot be.
Is there a statement in your affidavit? Respondent number 6 has filed an affidavit.
Yeah.
Any statement in the affidavit saying that yes, my name was there prior to 910?
No. No.
Yes, who appears for the government?
I.
Yes, yes. So looking at 910, who's appearing for? Yes. What is your stance, sir? Who heads the DSC from the department? DSC, who heads the DSC from the department? Who is there from the department in the DSC? Deputy Commissioner. Someone assists him from the education department at the district level? DO is the member secretary. Yes, the the district elementary education officer of the concerned district will appear on 6th along with the DIAS data. Huh? He placed something before the committee for consideration. What was placed? Where is that record? Huh? With the deputy commissioner. Who appears for the deputy commissioner? The DSC is a party here.
Yes, yes, my lord. My lord, in fact, this DIAS code was never disputed by any of the respondent, my lord.
Yes, we have to find out from the particular,
This is very specific, my lord.
from the
This was
particular
never
person
disputed. It is
concerned.
apparently on record, my lord.
The headmistress, has she filed any writ petition or something?
My
On
lord.
the headmistress, respondent number 5, any writ petition?
That was earlier
Pending.
filed, and then there was a direction from this honorable court
Yes.
to consider her case
Huh.
for provincialization of her services
Under?
under the 2017 Act, my lord.
Huh.
But that is also not considered by the my lord, concerned director, my lord.
What is that? Any contempt pending on that?
Probably, my lord. There is a.
Any contempt pending
Yes,
on that?
yes.
What is the contempt number?
I can provide, my lord, after, my lord.
Add 2. Earlier writ petition, contempt case number. Give us the details.
My lord.
We'll have the contempt and this one and everything listed together.
Yes. That will be
We'll
very-
take care of that, of this,
Or,
what do you
Yes.
call it, this ball of wool.
my lord,
We'll make it into a
may I
nice
make you,
bag.
my lord,
Yes.
submission, my lord?
Ah,
If possible, my lord, if the case is listed on Thursday, my lord, I can come with the records also, my lord, the copy of the earlier writ petitions order along with the contempt.
that we are only taking for a reference.
Yes.
That is not going
And
to assist
regarding, my
your
lord,
case.
the government side, my lord, they can also produce the, my lord, as your
Who is
lordship has
appearing
said,
for
they
the
can
government?
produce the
Who's appearing for the
DIAS
respondent
code
number?
for 2009. If it is listed on Thursday, my lord.
Okay, get someone from the government. Government or Dioksun? Hari, Purva.
But the decision was taken by TLC, and TLC is a necessary party, but TLC was not made party.
Huh?
What is the message of, taking the
The
decision?
chairman is the deputy commissioner, my lord. He is a party, my lord.
A2 Dioksun? A2 item or?
Can
And the member secretary is also a party, my lord.
Deputy Commissioner,
The DEO.
Pune appear করে, government advocate appear করে to DC. Scroll lead option to matter. Here matter, Deputy Commissioner matter.
On behalf of this respondent, your worship.
Who's respondent?
He's the DC, your worship, deputy commissioner.
You are there?
Your worship.
Another GP. Kindly ask him to come
No.
immediately. It will be,
No. My lord, after getting
file an
action
appeal.
of this case after for such a long period, my lord.
the appeal and other things will come in once there is a dispute to the question, which we cannot go into. In the present case, when admittedly the name was not there in the Dias Code prior to 2009 and 10, any person proposing that name to the committee itself has played fraud with the state of Assam. Is it not? State of Assam does not want to proceed against these persons, creating all this, creating a separate bench, civil bench 2. Is it not? Let us rein it. To some extent, we can try to rein it. We can at least attempt to rein it. Let people work honestly. Let people put up the proper papers. Let there be some respect for what the legislature passes, what this court decides. Is it not? So sending him to an appeal is showing a disposal. Is it not? And putting the actual problem created by use of the act into cold storage. We don't want to decide. At least not when we are there. We'll decide this way, that way. Rightly, wrongly. That word is very often used. Rightly or wrongly, this court has said. So let it be rightly or wrongly. We'll do it. Let Mr. G. Pegu be here. A little while later, let Mr. G. Pegu from the government be here. After some time.
My lord.
Let the government advocate be here, sir.
Item 23.
Today itself.
Today itself, yes.
Item 23 and 25.
My
Mr.
Very sorry, I missed the item today.
No issues.
Can you give us some?
We will put it up on Thursday if you want.
Thursday, my lord.
Thursday, because two items we have disposed of.
Yes, ma'am.
2011 Act, we cannot give a benefit.
My lord.
Punaboti Brahmo. 2017, if entitled, to be considered.
My lord.
That is what one order we have passed. If your clients agree to that.
My lord.
Otherwise, 11, I don't think we can give a relief.
My lord. There's one judgment of Mohar Ali's Sheikh judgment, my lord.
Ha.
There, my lord, the honorable court has said, my lord, if the otherwise they're entitled, my lord, and my lord, their names were considered, then there a right accrues. Because you couldn't have, my lord, made a segregation between the similar situated persons.
In the exact circumstances of the cases that we have disposed,
My lord.
Punaboti Brahmo held otherwise. Now, do we follow? Because Mohar Ali Sheikh was more on the basis of an overall challenge to the act itself.
Yes. But there, my lord, that part was, my lord, observed, my lord, that.
Point it to us on the next day. We'll try.
I'll
to see,
look
because
into that also.
the moment Mohar Ali Sheikh comes in, the moment I say not by me. Is it not?
Again, it's there.
Let us see on Thursday.
Well,
At the request of Mr. Dr. Learned Counsel appearing for the petitioners, list these matters again on the 5th of February.
I'm extremely sorry, my lord, I missed.
There is no difficulty. No difficulty. Mr. Pegu, we were taking up this matter. Apparently, the Deputy Commissioner heads the DLC. The DLC had recommended the name of the respondent number 6. Consistent stand of the petitioner, the school authorities, and also evident from the records. the Dias code prior to 2009 and 10, or even 9 and 10, does not contain the name of the respondent number 6. How did the name pass through? It passed through. When? We are keeping it as part heard.
2 weeks.
Huh?
2 weeks.
No, not 2 weeks. We'll give you 10 days at maximum. Cannot have 2 weeks. Because we'll have the education department also here. With what records were placed before the because let us see this that you have filed your affidavit, have you not? Have you brought on record that recommendation
No.
by the DSC in your affidavit? Why not? Kindly have page 87 for a moment. Page 87. We are not going into his case whether he should have been considered or not. We are now more concerned with whether the respondent number 6, does his name appear in the Dias data? Show us some sentence. Page 87, kindly read that paragraph accordingly.
It is not there.
Do you have the affidavit filed by the respondent number 2, sir? Respondent number 2, come to page 3, a page. Huh?
Page 94 has started.
If we tell you it is last but one page of that affidavit, wherever the deponent's signature is there, one page before that. 94.
94.
94.
94, yes.
In our record, it is 87.
That's
Anyway,
okay. No way.
if you read from paragraph A, what was required to be seen, whether the name of the school appears in the Dias code, name of the incumbent appears in the Dias data. The next paragraph says, his name does not appear.
Yes. But
They
regarding,
say.
yes, regarding Dias code, nothing has been stated.
Hmm.
No statement regarding Dias code.
Does not appear in, please continue. Does not appear. Where do you get this 11, 12 from? 9, 10 was the cutoff. Where do you get 11, 12? Why does the director refer to 11 and 12? Then what does it say? As per clause 4, the teacher of the venture education should be appointed on or before 31/12/2010. Accordingly, Dias Data every year, okay. So everyone, hence so and so recommended the services of Abdul Aziz. How cleverly you have avoided stating that Abdul Aziz's name appears or not. You have said petitioner does not appear. Abdul Aziz, no reference. It is also found that the name of Abdul Aziz has been appearing in the Dias Data from so and so time to so and so time. Where is that? Whose name? Was not recommended. Was not recommended. Respondent number 6 name was not considered. Very well. Was the respondent number 6 name recommended? Huh? Was recommended. So that there would have been one sentence saying that the Dias Data, his name was found.
Yes.
So this was an affidavit of September 2025. This has been made on the basis of records. Oh, none of it is based on records. Affidavit is based on what? Affidavit is based on what? Where? Show us paragraph 8. What does paragraph 8 say? You want to see our copy? Everything is on knowledge. Blank. It has been struck off in our copy. It is kept blank. We are very well with it. Yes, I heard Mr. So-and-so learned counsel appearing for the petitioner. Also heard Mr. Purkastal learned, no, you start with the government. Also heard Mr. Now how do we do it? We write the full name. Huh? Also heard Mr. G. Pegu, learned government advocate Assam, appearing for government advocate Assam, appearing for the respondent number 3, comma. Mr. G. Pegu, learned standing counsel, appearing for the respondents in the education department. Mr. A.K. Purkastal, learned counsel, appearing for the respondent number 6, and you are appearing for the respondent number 5. Respondent number 5, full stop. The thrust of the arguments made by the learned counsel for the petitioner is that although the name of the petition of the respondent number 6 did not appear in any of the Dias Data prior to 2009-10.
Or in the year 2019, in both minutes.
Or in the year
2019,
comma
9 and 10,
9 and 10 and
or prior to 2009 and 10, both minutes.
did not appear in the Dias Data of the year 2009-10 or prior thereto, comma, his services had been provincialized by the order dated
5/2/2021.
5/2/2021.
Page 28, yes, ma'am.
Full stop. The learned counsel for the petitioner has referred to provisions of section
2ZB of the.
2ZB
Yes.
of the so-and-so Act of 2017, Provincialization Act, huh? 2017, to impress that there were manipulations in the records placed before the district level, what do you call it, district?
District level scrutiny committee.
District level scrutiny committee and the state level scrutiny committee, which led to the petitioner's name being dropped and the private respondent number 6's name being forwarded for provincialization. We have gone through the affidavits filed in the matter. Stop. The affidavit of the respondent number 5, comma, who is the headmistress of the aforesaid school, has stated that the respondent number 6, whose name was, italics name was included in the Dias Code for the year 2009 and 10, was recommended by the District Scrutiny Committee Nagaon for provincialization. Mr. So-and-so learned counsel appearing for the respondent number 5 has submitted that due to an inadvertent typographical error, comma, the word not requiring to have appeared before after the word name and before the word was dropped, and the sentence should have actually read as the respondent number 6, Abdul Aziz, whose name was not included in the Dias Code for the year 2009 and 10, was recommended for provincialization. Full stop. He submits that the fact remains that the name of the respondent number 6 had not appeared in the Dias data of the year 2009 and 10. Full stop. Mr. G. Pegu, learned government advocate, appearing for the respondent number 3, shall requisition the records of the district level committee regarding the recommendation of which school? Pub Amlokhi A.S. Ahmedia LP School. And place before this court the details along with the Dias data which were taken into account while recommending the staff of the said school for provincialization under the Act of 2017. Next paragraph. Mr. G. Pegu, learned standing counsel at the Elementary Education Department, shall also requisition the records which may be available either with the Office of the Director of Elementary Education or with the, you say it like this, which may be available either with the respondent number 1 or the respondent number 2, containing all relevant factors, all relevant documents which are taken into consideration while proposing the name of the respondent number 6 for provincialization. Stop. The respondent number 1 and 2 shall ensure that the entire records which were taken into consideration shall be made available to the Learned Standing Council for the Education Department. Full stop. This court notices that in the affidavit in opposition filed by the respondent number 2, although a specific stand has been taken that the name of the petitioner did not appear in the DIAS data prior to 2000, up to 2011-12, comma. It does not contain any statement asserting that the district level committee, comma, the state level committee, or the office of the director itself, or the office of the government had at any point of time found that the name of the respondent number 6 had appeared in any of the DIAS data of the year 2019 or prior thereto. The respondent number 2, no, the Learned Council for the Elementary Education Department shall be supplied with the specific instruction as to whether at any point, whether during any of the scrutinies, the name of the respondent number 6 had been found to be available in the DIAS data for the year 2019 or prior thereto. Full stop. You have not made the SSA a party.
SSM is not a party, my lord, but the chairman of the district level scrutiny committee, as well as the member secretary of the district level scrutiny
The
committee.
Learned Council for the petitioner has sought for the liberty, now is granted the liberty to implead the SSA as a party respondent in this writ petition to facilitate the production of the DIAS data of the relevant years. Full stop. List this matter again on. Yes, now your choice.
10th of February.
You simply have to get us the records. All the records that were before the district. Oh, no, but the name is already there. Line to cut it, SSL line to cut it. Standing Council SSL to cut it. Give us a date April 13th, sir. Give us a date April 13th of February, sir. 10, 11, 12, 13. Give us one day.
Lord, can it be on 11 if possible, my lord? Lordship will kindly.
Hmm. Hmm.
Otherwise, you can't get. Okay. So I prefer 17.
Sir, our request was prior to 13th. 12th. 12th?
My lord.
Mr.
Only-
Pegu, 12th?
Yes, my lord. Lordship will kindly keep this matter as part of.
Oh, yes.
Yes, my lord.
12th?
My lord.
List this.
I can go.
There is already an order of this court. Not in this case, but in all the cases that every document being filed, copy has to be served to each of the appearing councils. So kindly you give them all the copies. Be it a respondent, be it a petitioner, everybody has to have copies. List this matter again on the 12th of February 2026 as a part-heard matter, full stop. It is made clear that in the absence of the records, the respondent number 3, no, respondent number 1, 2, 3, and who appears for the district DO, and respondent number 1, 2, and 3 shall make arrangements for a responsible officer to be present in the court to explain the circumstances. The in case the district, in case the respondent number 4 fails to provide necessary instruction or records to the other respondents, the respondent number 4 shall be personally present in this court on the aforesaid date. In case records and instructions are available, personal appearance would not be necessary. You don't have the records, you don't have the instructions, they would come.
Deeply obliged, my lord. Deeply
পাঠ আর লিখিছিটো পাঠ আর লিখিছিটো So the affidavit filed
Affidavit not filed, Lordship.
for the higher education department.
Lordship not filed, we have got the instruction on 10/12/2025.
Ah.
The petitioner had allegation of complaint, Lordship.
Two?
Regarding the farm number 5.
Ah.
So now we have forwarded it to the selection committee, look into it and give the marks.
No, this is from 2022, sir.
Yes, Lordship.
This is when, this is of 2022. Don't show me of something of 2026 now. Tell us what was the allegation, sir?
Allegation is with regard to the fact that these postdoctoral marks have been given to the private respondent. And we are saying that this postdoctoral marks is not, the private respondent is not entitled to get that particular marks. This is the very
Okay.
small thing, because if this particular marks is not, is deducted from the, on the part of the respondent number 5, then the petitioner can be taken into consideration.
Who gave the marks?
This selection committee, Lordship.
The entire selection committee.
Exactly, Lordship. And they have not appeared in
What?
19th January. Last paragraph.
governing body and the selection committee, both of the parties in the writ petition, in spite of receipt of the copy of the writ petition, they have not appeared.
You have given another representation,
Exactly.
your petitioner, after all this litigation. Litigation is of 2022.
Yes, Lordship. Because,
On 19th, we have.
Lordship can fix a short date so that. they
Just a
can update
minute,
the
advertisement
instruction.
issued by the so and so. It's going to- There was an earlier round of litigation. In the earlier round of litigation, there was a direction for you to look into the grievances.
Yeah.
What did you do?
Petitioner was awarded marks. Basically, some marks. For each, gold medal. He was negative.
Where is the order of that court? Where is the order of the court, earlier order? Page 51,
Yes,
huh?
yes. Hmm. And accordingly, I filed the petition, I filed the
just a minute.
representation, all the
Just a
relevant
minute.
documents. Yes, Lordship.
Where is your representation?
It is the next page, Lordship. Yeah, page number 54.
Hmm?
Annexure 10.
Any statement here that the other person has been awarded marks wrongly? Postdoctoral marks, anything?
Lordship, in paragraph number 5.
Hmm.
Paragraph number 5.
Hmm. No, you did not talk about the postdoctoral
No,
thing
that
here.
has not been mentioned, but it has been mentioned that this no teaching experience will be considered. The teaching experience is not there. So that aspect of the matter has not been taken into consideration by the selection committee.
Now your fresh representation has been filed
Yes.
and you have asked for what?
Yeah, that the as per logic, last paragraph logic.
Huh?
To verify, whether this teaching experience is, how they have the selection committee has given that teaching experience to that person and give the justification. To give the experience.
The other person has already joined.
No, he has not joined.
The respondent number seems to. Post is lying vacant
Yes. Because of the pendency of the requisition.
from 2018.
Yes. And since 2022, after 4 years, the petitioner was compelled to file another representation. Now they are intending to process.
Nineteenth of January. This exercise is required to be completed within 29th of January. We'll have it on the 3rd of February.
Lordship, the same thing they did in page number 46 also, that asked for the teaching experience of the private respondent. If your Lordship kindly see, page number 46,
Therefore, we have.
that was in the year 2022.
Yes.
Page number 46 now. Yes.
Now, certified the election committee should not give justification.
Where,
It's in the letters.
where do you talk about justification?
First para, therefore you are requested. May I read that? Therefore, you are requested that the matter before the selection committee for the post and to award the marks to the selected candidate as per guidelines. of
Okay.
So allow proper justification.
Heard Mr. S.P. Chaudhary, learned counsel appearing for the petitioner, also heard Mr. A.R. Tohvilda, learned counsel appearing for the Higher Education Department. By producing a letter dated 19th January 2026, the learned counsel appearing for the Higher Education Department has submitted that that the directorate has has requested the principal of the Kachar College, Silchar, to place the matter before selection committee for the post and to award marks to the award marks to the elected candidate.
Along with proper justification.
Along with proper justification, full stop. A perusal of the letter shows that have you made him a respondent, this particular person?
Yes, yes. He has
That
already.
the respondent number 5
Respondent number 5.
was recommended, was shown as the selected candidate for the post in question, however, by awarding awarding marks for his postdoctoral research program, full stop. The learned counsel for the Department of Higher Education submits that such marks could not be allotted as per the scheme.
No, it's not available as per the 29/1/2020 that guideline.
Guideline
That
is there.
such marks were not required to have been
It is mentioned
allotted. Where?
It is mentioned as paragraph.
In the letter, na?
In the letter.
In the the learned counsel for the Department of Higher Education, Department of Higher Education has submitted that such marks could not have been awarded under teaching experience.
Yes. As per the HC guideline number 7.
As per the guidelines dated 29/1/2022. Is it?
Yes. Log it is.
202 full stop. You have made the selection committee a party
Yes.
represented by the
four.
principal.
Principal and the selection committee both.
That submission that should not be awarded, that is not mentioned, but as per the guideline, for teaching experience and library experience, that experience must be awarded. Then how the selection committee is giving the marks, that we stop for the justification.
I don't understand.
That cannot be the court invested.
Okay, you cut out that portion. Cut out that part. Learned counsel for the Director of Higher Education has submitted that such marks could not have been awarded. That sentence you remove. Full stop. Who appears for these two? No, not the private respondent, the,
3 and 4, nobody is appearing, Lordship.
have they been served?
Yes, service is complete for 3, 4 and 5.
The service of notice on respondent number
3, 4 and 5.
3, 4 and 5 are shown to be complete
Yes.
as per the records of the case. However, none has appeared for them till or today. Full stop. The post which is in question has not been filled up from the year 2018.
2018.
Then how does that this
2022, sorry, Lordship, 2022.
has not been filled up from the year 2022?
22.
Full stop. List this matter again on the 3rd of February 2026. Enabling the learned counsel, enabling Mr. Tavilda to place before this court the report from the selection committee through the which would be received through the principal of the Kachars College, Silchar. Mr. Tavilda is permitted to send a downloaded copy of this order to the respondent number
3.
Respondent number 3 and 4 through the office of the principal of the Kachar College, Silchar.
That's one number 3.
That is the respondent number. Governing body is the respondent number 3. Principal is not a party, sir. Through the
Governing
office of the
body.
principal, so and so.
Second party, because we directed to get that.
No, we'll allow you to send a copy. In case we do not have the instructions on the next date, we'll ask the principal of the college to be here to represent. Good stuff. So that the secretary of the governing body is has knowledge of this, has knowledge and notice of this order. Full stop. In case the justification or reconsideration of the marks allotted to the respondent number 5 are not made available to the respondent number 2 as sought for by the letter dated 19 January 2026, the principal of the Silchar of the Kachar College, Silchar shall personally remain present on the next date fixed. When did we fix it? 2nd?
3rd of.
3rd. We'll keep it on 5th.
Yes. Yeah.
On it will list on 5th corridors. 3rd, no, 5th. On the 5th of February 2026. We cannot have a post vacant like this.
Can be on 6th.
On the 6th. 6th of February. We will not keep the post vacant like this. Either the writ petition is allowed or it is dismissed.
Yes.
Something happens.
Okay.
27.
Letter may be kept as a part of the communication. May be
The letter dated so and so is kept as a part of the record and marked as annexure so and so. Marked as X. So we'll come back after. Eight. Yes, Mr. Chakraborty.
It's a very hard pressed matter, my lord. I am 76-year-old, my lord. I'm not getting pension till date, my lord. And
Provisional pension is also not forthcoming.
nothing, there's some controversy, my lord. Some controversy is there.
Show us what is the consumer this thing. There is no affidavit on record.
Everything has been done, my lord.
Affidavit is there.
Affidavit has come from respondent.
Why so?
Lordship, the council is having.
Who is the council?
Lordship, is on.
Kostov.
Yes.
On a prayer made.
Hear it and make it part hard, my lord. It's very, otherwise
We
never
have not
felt like this.
started. We have not started the hearing.
Well-
So what we do is we fix it on Thursday,
Thursday.
and let Mr. Gogoi come.
My lord.
Mr. B. Chakraborty, Learned Counsel appears for the petitioner on a request made on behalf of Mr. K. Gogoi known as Standing Council Higher Education, placed this matter again on the 5th of February 2026. We'll take it up on that day.
Council was praying for day after tomorrow, madam.
So
Some problem
today
maybe-
is Tuesday. Oh. The calendar before me,
Yes.
Thursday is shown as 5th of February. I'm sorry. It will be not 5th of February, it will be 29th. 29th of January 2026, huh? Thursday, spring for Thursday. Yes, Mr. Sinha.
In this case, Lordship, petitioner was earlier directed by this court to consider. He's a Sanskrit teacher, Lordship. His case was not recommended for provincialization, although he's eligible. And the court, Lordship, directed to consider. And Lordship, the court, the respondent on one occasion, they said he was not recommended because there's no student appeared in SLC examination.
Okay.
That was interfered and directed to consider petitioner's case, Lordship. That was not complied till date, Lordship.
Where do you find
recently,
that order?
That order, Lordship, will find at page 48, Lordship.
Page 48. Okay. Now, you also have to tell us, once the 2011 Act is gone.
Gone, but Lordship, the respondent has appointed similar situated person on the Lordship on 15/7/2024, Lordship.
Okay.
That Lordship will find.
Following the
50
judgments of this court,
under
na?
Lordship, it seems they are appointed under old act because there's no recommendation, no DSC, nothing, Lordship. Only they said in their affidavit that it has been done in pursuance to Supreme Court's order.
Supreme Court order, what did it say?
Yes,
That was in the matter of Kamal Sojati.
Yes, yes, Lordship. One Kamal Sojati's case, there are a group of 6 persons in that case. That was also, Lordship, in that case, state has filed a writ appeal. That was, in that case, delay was condoned by this court.
And then,
then went to Supreme Court by the petitioners. Their Lordship, the Supreme Court has directed to implement that order. That order, Lordship, will find a phase.
in your case, there has been no appeal.
There is no appeal,
There
no
is
review,
appeal.
nothing.
Yes. Who appears, madam? You appear? Tell us.
Both the cases we have filed our. Stand, your lordship.
As to what? You have not read the affidavit.
Page 67, I would like to take you straight in paragraph 5. of the
5.
affidavit.
Yes.
Position, that is a repetition 4956/2024, Jagannath Bojai. I'd like to read it here, your lordship. That the deponent begs to state that the inspector of the school Dhemaji sent a proposal for provincialization of service of teaching and non-teaching staff of the petitioner school. That is Pragati High School, where is and district Dhemaji with the recommendation of BLSC. As per provision of the Assam Venture Education Institution, provision of Assam Service Act 2011. Accordingly, the service of the eligible teaching and non-teaching staff of the same school were provincialized under the Assam Venture Educational Institution Provincialization of Services Act 2011. Except the service of the
Madam,
in the instance.
Madam, we can read a little more quickly than your spelling out the affidavit in opposition to us. That does not help. Now, at paragraph, will take you to a more important paragraph. You are coming to page 69. Page 69, you have referred to 68, we'll read it. 69, you have stated that in the case of Saroj Upadhyay, claim of the petitioner cannot be considered. You had issued an order. that claim of petitioners cannot be considered in compliance with, in reference to some Saroj Upadhyay case. You have not referred to the present case. In the present case, there was a direction that you should consider him under the 2011 Act. No review, no appeal. Can you go out of it? Can you escape? He may have a right, he may not have a right. But without reference to the absence of students, this court had directed you to relook into the matter. It was not done. Matter is pending from 2016. Your affidavit does not refer to the same, prolonging the litigation in the court. What to do?
I may allow to file one additional affidavit, your lordship, reporting that we earlier cases, your lordship is standing order. As in this affidavit, your lordship, nothing is stated. Only the taken stand, your lordship, the claim of the petitioner cannot be considered as no student in the subject of such.
So there are several cases like Komal Sajati. Tell us why their cases is not similar like Komal Sajati and why is it more similar to Saroj Upadhyay? Convince us. Jagannath Gujrial had an earlier case of 2014. And Saroj Upadhyay, Jagannath Gujrial and Komal Sajati were taken up together.
Yes.
And you say other similarly situated persons in Saroj Upadhyay, Jagannath Gujrial and Komal Sajati. So Komal Sajati and Jagannath Gujrial is similar. You admit that? Komal Sajati you have provincialized. Jagannath is item number 30.
30.
Show us after this affidavit, how do you say that Jagannath is not similar to Komal Sajati? It is your affidavit.
68, your lord.
Paragraph?
68, page 68, your lord. We have taken once step.
You have two affidavits. No. No, this is Saroj Upadhyay. You are Saroj Upadhyay.
Yes, Saroj Upadhyay and Gujrial both.
Now, Saroj Upadhyay apparently has been rejected.
That rejection was interfered by this court also. And also directed to consider. That was not done.
Sit here and assist. Why the far off? Distance mode, why? See, we are just trying to bring a closure to illogical things. Komal Sajati, Saroj and Jagannath are similarly situated is the sentence. Komal Sajati in fear of contempt done. Supreme Court order does not condone the delay, does not say that we are only condoning the delay. The Supreme Court says that no, Komal Sajati should have got it.
Yes.
Now, when your affidavit says that yes, they are all similarly situated, tell us something. Or we are disposing it off otherwise.
No.
Eh? Can it not be today, some at later point of time, a little later? Huh? Friday?
Friday.
At the request of the Learned Council for the Elementary Education Department. List this matter again on Friday. Give the date. Friday. 30th of January. 2026. Full stop. The affidavit filed by the Director of Elementary Education or Secondary. Director of Secondary Education. Quotes as follows. You would give. Where was that paragraph?
মোৰ লগত কোনোবা এখন পঠাই দিয়া কৰিলো
I cannot. When it's Friday.
Quotes as follows. Your first order was what date? Quotes as follows. Para 69 from page A to A, huh? From A to A. Page 69. I've given in blue, right from A to A. In the next paragraph, you write, the learned counsel for the petitioner has submitted that the petitioners are similarly situated to the petitioners who, to the incumbents who were petitioners in Kamal Sajati and others versus State of Assam. Within bracket, you give WPC number 4644 of 2014. Full stop. It is stated that the petitioners in Kamal Sajati and others have been given the benefit of provincialization following an appeal preferred by the state, which was where the delay was condoned, and a dismissal of the appeal on the SLP preferred before the Honorable Supreme Court by the petitioners therein. The order of the Supreme Court in SLP 985 of 2023 had recorded as follows. Page 56, paragraph 17 and paragraph 18. In the present case, it is noticed that no appeal was preferred by the state against the order of which the petitioners now seek implementation. On the next date fixed, the learned counsel for the Education Department shall address this court as to why a similar relief as granted in Kamal Sajati should not be granted in the present case also. Counsels are requested to be prepared for disposal.
Obliged.
You're right. At the top, you're right. Where we had said, madam, where we had said, heard Mr. Sanjana, there, pleadings are complete. Pleadings are complete. His file is no affidavits.
He did file or affidavit. But here, your lordship, every pages, your lordship, he has signed, the respondent has signed it, your lordship. So unfortunately, we could not file.
Respondent has signed every page of the affidavit. He's welcome. He has read every page. Why should that delay the filing of the affidavit?
And for your lordship, one annexure has not been provided to us, your lordship.
Will impose a cost on him who has not provided the.
One day may be given, your lordship, one more day, your lordship.
List this matter again on Friday, 30th of January. Let the affidavit come.
Yes.
30th of January, by which time?
On second, my lord.
On the 2nd of February, 2026, allowing Ms. Das, learned standing counsel for the Education Department, to file the affidavit in opposition. The learned counsel for the petitioner, allowing her to file that. Yes. This all pages signature is good. It is not bad.
Already availed the last chance also, my lord, on 2 occasions.
2 occasions, last chance.
Connection has not been provided to us. I already.
Lordship may observe that no
communicated
further chance will be granted.
Huh?
Lordship may observe that no further chance will be observed.
On second, we will see.
it. Deeply obliged.
57 and 58 supplementary.
Huh?
Supplementary of this 57 and
48.
Your Lordship.
Yes.
It directly pertains to provincialization of those two petitioners of Catholic Mission ME schools, Your Lordship. Lordship, kindly say the last order, Your Lordship. One rejoinder, we have filed a rejoinder against the affidavit filed by the respondent number 4, Your Lordship. But that is not on record, Your Lordship.
Till date.
Lordship, even we charged it in the section also, that is not even there, Your Lordship. So, Your Lordship, we have filed it again today itself, Your Lordship.
Okay.
So, Lordship may fix it maybe for tomorrow, Your Lordship. And the early morning we'll mention for the,
No, is it so urgent that it should be taken up tomorrow?
because,
Can
Your
we
Lordship-
not have it at the beginning of the next week?
because Your Lordship, it's a matter of 2013, Your Lordship.
Could be, but
One-
5 days, not harm
One
much.
more thing is there, with due respect, Your Lordship, one of the petitioner is going to be retired, Your Lordship.
In February itself, January,
January itself,
he
Your
will
Lordship.
reach the age of.
So, Lordship, my humble prayer, Your Lordship.
She's
the
praying
vis-
for tomorrow. With her affidavit, you given a copy.
Yes, Lordship.
At the request of the learned counsel for the petitioner, list this matter again tomorrow. And along with the affidavit, additional affidavit, rejoinder affidavit filed by the petitioner, Mr. Petitioner to ensure that there are no objections pending with the registry.
What's your price?
A big load off my shoulder, yes. Doctor? This will take a big load off our shoulders.
Lordship wishes to be part by Lordship, then it's okay, Lordship.
This is a matter of, this is which item? Item 49.
49.
You're gonna
Wait,
institute-
Mr. Raj.
Sir. Admission, okay. Yes, sir.
Lord, my learned friend wants that I should do my part, they will do their part on another day.
If it is comfortable with you, we have no difficulty.
And the matter relates to supersession of the petitioner. Now, he was aspiring for a promotion from grade of manager to senior manager. They call it E6. My lord, during the pendency of the case, the petitioner has also been promoted to E6.
Okay.
But now the issue is, my lord, of antedating the
Antedating.
promotion in the event I succeed. Now, my lord, the basic point is the petitioner's merit was not properly assessed. That is my basic ground of challenge, my lord.
So when would Mr. Tiwari be available, sir? When would Mr. Tiwari be available?
Next week, Thursday to next Thursday.
Next Thursday, no.
Tuesday.
Next
on the
Thursday,
week?
my lord, next Tuesday, I'm not there. Next week, I have some difficulty, my lord.
Next week, okay. Next week is
Huh?
February.
Or 17, 18, 19, any date.
We can fix something up to 13th. Till 13th I can fix
Yes.
dates as of now.
Or can it be done like this, Milord? Let me finish my part
yes.
today. Lordship will, তুমি লাগে বেলাইন কৰিবা? Now, my first point is, Milord, the DPC did not follow the promotion policy. As a result, Milord, serious prejudice has been caused to the petitioners. Now, if your lordship would kindly come to page number 77, Milord, of the writ petition.
Yes.
Please come to 10.5. Milord, this is the modified promotion policy. On the left-hand side is the pre-amended and right-hand side at page 77 is the modified policy. The DPC shall interview executives in the grade of E2 and above and up to E6 with a view to ascertain in their suitability for the next higher position. Marks for interview shall be awarded by DPC, taking into consideration factors like, these are the considerations: educational qualification, consistency in performance, professional knowledge, ability to reason out logically, presentation of ideas coherently,
Environmental awareness.
environmental awareness, leadership potential for decision making, communicational skill, sense of involvement, commitment to the organization, recognition, appreciation letter of director, CMD for commendable performance, warning, caution letter issued by disciplinary authority. So at least this 10 out of the 12, my lord, barring the last two, these are all attributes which my lord represent some objective standards. So my lord, so decision making process, the DPC, my lord, minus must reflect that due consideration was given to these aspects before awarding marks. Now here what has happened, my lord, those who could not, my lord, get the promotion or superseded, all were given 6 instead of 8 mechanically.
Yes.
Now, if your lordship would kindly come to page 74, my lord. 4.7.
And merits.
Promotion up to E6 grade shall be based on eligibility and merit subject to suitability. In other words, essentially, my lord, is a merit-based criteria. Then my lord will kindly come to page number 76, my lord. Now, qualifying service is also required.
Yes.
Now, if your lordship would kindly come to E5 on the right-hand side, E5 to E6, 4 years. Am I clear, my lord? So 4 years qualifying service is required. In order to encourage employees to acquire higher academical qualification leading to improved performance, maximum up to 5 marks shall be awarded for promotion from E2 to E3 and above on the following manner. Additional degree, diploma, minimum duration 1 year in service with so-and-so, so-and-so, so-and-so. So if we get any additional diploma or degree, then we'll get 1 mark. One of my grievances, my lord, I have this which has not been given to us. Now, my lord will kindly come to page 79. My lord, I am I'm now presently I'm demonstrating the criteria, then I'll come to the facts. Promotion from E2 to E6. Kindly similar, promotion from E2 to E3, E4 to 3 to 4, 5 to 6, grades shall be based on eligibility, merit subject to the percentage of eligible executives. Marks secured by each eligible executive from PAR, seniority, qualification, field posting, and marks awarded by DPC will be aggregated. So, my lord, under 5 different head marks will be given. That is PAR, seniority, qualification, field posting, and marks awarded by DPC. Then sum total of everything taken together will be the, my lord, marks based on his promotion will be given. Performance appraisal report shall constitute 60%, 60 marks in all. The appraisal system will be on a live point scale, that is outstanding, very good, good, average, poor, etc. Each of these ratings have been defined in the format of appraisal report for the purpose of aggregating names shall be allotted to various ratings as under. Now, please come to page 80, my lord, 11.5.
No, page 80 at the top.
Yes. Outstanding
Outstanding is
12,
12.
very good 10.
What is on the other hand? The very good, good, average and
Now
poor.
it is
Up to
12.
14.
Earlier it was 14.
So this is earlier.
Right hand side is the present one.
My mistake. Yes, earlier.
So if one is outstanding, then he'll get 12.
12.
Very-
Earlier there was no outstanding part.
Yes, outstanding was not there. Now please come to 11.5. Interview 15 marks for promotion from E2 to E3, E3 to 4, E4 to 5, 5 to 6. DPC will award up to a maximum of 15 marks to each eligible executive for interview in terms of subpara 10.5 above, keeping in view the relevant factors defined therein. Then Milord will kindly come to the next page, Milord.
Just one clarification may I have?
Yes.
When we talk of 11.5,
Yes, Milord.
15 marks to each eligible.
Maximum mark
15 marks. Now in 8.1.
1 second.
In 8.1.
Yes.
1 mark each for additional degree. So if one has an additional degree, he can give. If he has got 6 degrees, additional diploma degrees, he will be given 5. 5.
For 1, he'll get 1.
1.
Yes. Now,
Yes.
11.5, it says, Milord, interview component is 15, maximum.
Total.
Now, another important factor is 11.7 at page 81. DPC shall award a total of 10 marks for field exposure as under. That means, my lord, if somebody sits in the head office, then he will not get promotion. He must have field exposure. That means he must go to Ranganodi project and all these projects. Now, our allegation is, my lord, most of the persons who were promoted, they do not have field exposure. Without, this is a must. Then my lord will kindly come to page number 84, my lord. 12.9. If your lordship would kindly come to 2, for promotion
4
to
years.
the grade of E6,
4 years.
minimum of 4 years experience at the level of E2 to E5. So during the period when one is in E2 to E5, he must have 4 years field exposure.
From when you, acha, mandatory.
Now, my lord, sum total you will get at page 86.
E2 to E5. So within the entire period from E2 to E5, we can have 4 years anytime.
Now, page 86, my lord. This is how, my lord, modified one on the right hand side. PAR, that means ACR maximum he can get 60. Seniority 10 marks. Field exposure 10 marks. Interview 15. Qualification marks 5. Total 100. And kindly see, my lord, minimum qualifying marks in interview 8 for general and 7 for reserve category candidates. Extreme right hand side.
Interview 8 and SC, ST 7.
That means, my lord, maximum one can get 15, but you will have to get 8, or else you will not qualify for promotion. That is for
No, that also I think the performance report that has to also be taken into account 44 and 40.
Yes.
So even if he scores in the interview 9 and he does not reach 44, if he is 43, he goes. Done.
Correct. So this is how, my lord, this is how the promotion policy has been framed. Now let us come to the facts of the case, my lord. Let me first come to the point of this, my lord. Assessing my merit at the interview. First, let me deal with that part. Lordship will kindly permit me to read 3 paragraphs from my writ petition, where we have explained everything. Lord will kindly come to paragraph 17. It's slightly longer period, my lord. I'll permit me to read it. Lord, it starts at page 20, para 17. Where we have quoted the, my lord, clause 10.5 and all, then interview part. Then please come to E, my lord. Sorry, C, my lord. C, at page 23. Or to be precise, let me read from, my lord, D, page 22. Last 2 sentences at page 22, that the 12 different aspects basic upon which the DPC was to award marks in favor of the executives were included within the factors basing upon which PAR of the incumbent is prepared for a particular year. In fact, my lord, while writing the ACR, those were the very
That is what I was thinking. The marking system given is ACR because the DPC has to look into the API to find out how much mark the DPC has to give.
Absolutely. Absolutely.
The attributes which I saw
is
what we usually see in a central government API.
Yes.
Marks against this marks.
Very correct. The marks grade in pair of the incumbent is based upon marks secured by incumbent under 4 different heads. Key performance area 75, competency 15 mark, value 5, and potential 5. Under the head key performance area aspect pertaining to assigned work, fronts are taken into consideration and marks are awarded against them. Under the head competency, 9 different aspects were taken into consideration and marks are awarded against each of them. Under the head value, 10 different aspects are taken into consideration and marks are awarded against each of them. Under the head of potential, 5 different aspects are taken into consideration and marks are awarded against each of them. That at least 10 out of the 12 different aspects appearing in clause 10.5 of the promotion policy as amended on 29/1/22 can be related to the marks taken into consideration against different categories under 4 different heads, that is key performance area, competency, value and potential, as well as comments in the attribute, integrity and remarks in awarding final marks in PAR of the incumbent. Details of those categories are as under: consistency in performance, all attributes of key performance area, professional knowledge, ability to reason out logically, presentation of the ideas coherently, environmental awareness, leadership potential for decision making, communication skill, sense of involvement, commitment to the organization, warning cause letter issued by disciplinary authority, all attributes of the mark. That the DPC can award maximum of 15 marks in interview, and while doing so, 12 aspects referred to in clause 10.5 is to be considered. In the absence of any specific question discussion with regard to the 12 aspects, the petitioner was under the bona fide impression that DPC took into consideration the marks secured by the petitioner in the peer against at least the above referred 10 aspects. Other two aspects, educational qualification, recognition, appreciation letter for commendable performance were to be assessed, basing upon the records available against the petitioner. The petitioner had consistently secured higher marks against the 10 aspects as referred to earlier from PARs since last 5 years. But in the interview, the 12 factors were not assessed individually, and marks awarded to the petitioner against those factors individually and are not discernible from the annexure appended to the RTI reply dated 26/4/22. It is also not clear as to on what basis the DPC awarded 6 marks, failing disqualifying marks out of 15 in favor of the petitioner in the interview. There were 7 members in the DPC, and any person with minimum common sense would judicially think and award more than 6 out of the 15 in case of an incumbent who had secured 56 out of 60 in the marks awarded for the last 5-year year.
That is exactly what was coming to my mind.
There's something very bad had transpired in the interview, which of course is to be recorded in writing by the members of the DPC. That in absence of specific question discussion involving each aspect of 12 as required to be considered in terms of clause 10.5 of the promotion policy and the rules of the executive amended on so and so by DPC in respect of the petitioner, it could not have been taken a completely adverse view against the petitioner in respect of 12 aspects which was in direct conflict to the marks awarded in peer maximum for the petitioner for the year 2016-17, 17-18, 18-19, 19-20 and 2021 against the attributes referred to in paragraph 17, see above. As such, DPC has acted in violation of clause 10.5 of the promotion policy and the rules of HPC. So my basic case is, my lord, while assessing my APR on the basis of the same very attributes, I got 56 out of 60. And how can I get 6 out of 15, my lord, when the same very attributes are you are assessing? My lord, I'll come to other aspects. So, my lord, to show my bona fide, my lord, please come to page 110, my ACRs. Kindly, it is for the period 1/4/16 to 31/3/17, my lord. Kindly see. So everything is, my lord, in order. Eventually, my lord will kindly come to page number 119. Sorry. 116, my lord. Preciseness and promptness, I got 10 out of 12. Preciseness, 29 out of 32. Under different heading, my lord. 4 out of 8, 10 out of 12. Then page 117, 14 out of 16, 18 out of 20. So, my lord, all I have secured very, my lord, rather outstanding marks. Then, if your lordship would kindly come to page number 122. So, in sum total, I got, my lord, 63. So, this is how, my lord, I have annexed for all the relevant years, whereby marks are outstanding.
Out of total 300.
Yes.
63.
No, my lord.
Hmm?
I think 63 would be out of 100. I think that is how I think out of 75, 63, my lord.
Out of 300, 252.
252. $75 was the maximum. I got 63.
Hmm.
This is for 16, 17. Similarly, for the other years also, up to, my lord, page number 131, all my ACRs are given. Where from lordships you will find, end of the day, my lord, my rating was 56 out of 60.
Do we have the DPC?
My lord.
Do we have the DPC
No,
proceedings
DPC
for
is
us?
in the records.
It's in the records.
Record. We are shown to us, my lord. Now it is in the court of Jaya. I think the records are with the court, my lord.
আছে নেকি? কিবা বেলেগকে আহিছে নেকি কোৰ্টত ৰেকৰ্ড চাওকচোন কিবা ৰেকৰ্ড ফাইল এটা নাই আৰু ফাইল
Now, my lord,
just a minute, Mr. Chaudhary. We had one thing in mind. If the DPC varies much with the assessment made in the APRs or the gradings given in the APRs, we remember reading somewhere that it has to give a reason. That is just what I was trying to find out if any reasons
let
have
me
been
give the
given.
legal position subject to correction, my lord.
Sir.
Now, DPC is not bound to go by the APRs strictly.
True.
They may devise their own procedure and they may make their own assessment. That is also permissible. But, my lord, can it so happen that APRs were, when it were prepared, I get 56 out of 60, and in, my lord, the same assessment done by some DPC, I get 6 out of 15 means, my lord, it is not even 50.
Therefore, the DPC had to record a reason. In the while writing the APR, this particular warning was not taken into account.
Besides,
his failure in such was not taken into account. That part had to be there.
It is something like, if your lordship would recollect, supposing a man says that my age of retirement should be so and so. Therefore, I have been irregularly retired before. So there is a cross check in the SR 13 where it says, all right, we accept your view that it was wrongly recorded. Now let us see, when you entered government service, you were 18 years or not. SR 39.
That part had to be there somewhere.
It is there, my lord.
Unfortunately, we do not find the record file here. There are only two copies here. Were the records given? Not find it. We have been requesting again and again, the court has to be taken as an entity, not in the manner in which someone took it up who was sitting in the chair. So if there was a record, the record has to be here. Counter affidavit, reply, notice. No, there is no noting saying that the record was. No, you have to find out from your department whether the records were given and on what date then. Because here we do not find any order. On 25/6, Learned Council shall retain the original records. Retain. Thereafter, nothing is here. Kindly find out. Up to the time it was hearing concluded, there is no record. The order is of 22. Last order is of 25/6, 2024. Please find out. Yes, sir.
Yes. My lord, so this is my argument regarding where the DPC has gone wrong in assessing the merit of the petitioner.
Yes, sir.
My lord, the second point is
How many people were promoted?
one second, my lord. One second. I'm giving the figure, my lord.
You find it page 173 of the additional affidavit, something was.
My lord, in all,
Huh.
total 233 candidates were called for interview
Yes.
for promotion against 139 posts,
Hmm.
out of which, my lord, 233 were shortlisted candidates.
Hmm.
194 were from general category.
Hmm. How
Out
many
of
were
two-
promoted?
139 were promoted in
139.
different, my lord, grades, my lord.
Right. 60.
And out of 94 unsuccessful candidates, 77 candidates
Got
belonging to
6.
general category were awarded 6 marks each. Out of 94 unsuccessful general category candidates, 77 were of general category and they all were given 6 marks, mechanical.
That we find in page 174.
Unsuccessful, general category.
Page 174. If I'm
Yes.
not wrong. It's the detail given.
If your lordship would kindly come to page 106, my lord.
Hmm.
This is the, my lord, result sheet pertaining to the petitioner. Kindly see, my lord, he got total 72, but by virtue of the fact that he could not qualify in the interview, his case was not considered.
Think we will need, I think Mr. Gautam can arrange for a typed copy of page 106. Page 106. The top
We'll
part
give a copy.
we are not being able to read the top part
Correct,
of
correct.
column 8 and column 9.
Yes.
Those 10 and 0. Wow, what was 10 and what is 0? Additional
That will
qualifying marks is
give
0?
a legible copy, my lord.
Yes.
A type copy for you, my lord. Huh?
Yes, sir.
Yes.
Understood.
Now it cannot so happen that everybody 77 will get 6. It was all mechanical.
Hmm.
Now, my lord, the next point is very important, my lord. If your lordship would kindly come to page 327. P27.
Yes.
This is a circular issued by the Millard NHPC authority. E-Office has been implemented in NHPC Corporation with effect from 1/9/2019. Further, from time to time, it has also been advised to create and send the file through E-Office for obtaining approval of higher authority. However, instances has come to the notice that some of the departments are still processing physical files instead of e-file. The same has been viewed seriously by the management. In this regard, CMD has desired that henceforth all files shall be created and sent through e-Office digitally only, and no file in physical form shall be created and sent, and same shall be ensured by respective HODs for strict implementation. Now, this present promotion exercise, my lord, it was not undertaken in terms of this E. Therefore, leaving lot of room for manipulation. Now, what had happened in this case, my lord, as per the promotion policy, the exercise should start from 1st of April. Now, if your lordship should kindly come to page number 218, my lord. Page 218. Please come to 218. And listen, my lord, it is Human Resource Department Establishment Section 26-22. Whether this exercise should have started on 1st of April. Now, my lord will kindly come to page 220. In view of the 8.1, in view of the above, it is proposed that Departmental Promotion Committee comprising of the following executives may be constituted. Now, this was done at the instance of Director Personnel because, my lord, the MD was retiring on 31/3/22. Fine. Now, if your lordship should kindly come to page number 180, my lord, part of our additional affidavit.
What is this 11.0
At page, my lord,
at page 221?
221. 1 second. my lord.
We are considering the promotion to E6. 11.0.
Yes. E6 is the grade with which we are concerned.
11 will have some relevance? Or
Yes, as per the promotion policy to consider a promotion from grade so and so, so and so, so and so, DPC shall be considered Director of Personnel. Yes. Accordingly, Director is kind for consider. This was given by the MD, my lord.
so
Original
this was given on
22. 1 second. 26 to
26 to
Yes. Now, please come to page 180, my lord.
director had to
Yes.
form it. Page 180.
Yes.
183. 180.
Or if your lordship, I'm sorry, my lord. If your lordship would kindly come to page 56 of the writ petition.
56.
Page 56. Constitution and role of DPC. The Departmental Promotion Committee shall be constituted only once in a year, effective from 1st April. The vacancy will be calculated after considering the following. So because he was retiring on 31/3, my lord, therefore he did. DMD. That's our specific case. Now the averment lordships will get at para 9, page 180 of the additional.
But as per this page 221,
Yes, my lord.
for grade,
Up to 6, E6.
no. If we have page 228, point number
8, my
8,
lord.
this is only up to E5
Yes.
and above up to E5.
Huh.
8.1 relates to up to E5.
Yes.
So if
no.
we come to 11,
Yes.
for
11,
E6,
11.00.
11.0, it is yet to be formed because the director personnel had to do it.
Yes. Correct. But it was done at the dictation of the MD. That's what I'm trying to show, my lord. Page 58. Please come to page 58.
Page 58. Yes, sir. No, 58 does not say so.
My lord, this has been slightly modified. Para 58. This is the 19 policy, promotion from E2 to E3, E3 to E4, E4 to 5 and 5 to 6. This is okay. Promotion to these categories shall be on the basis of seniority subject to suitability. Now please come to the, my lord, amended one, which your lordships will get at page number 11. What? Yes. Now please come to, my lord, page 79.
Rule 10.2 is what they said. 10.2.
Yes, please come to page 79, my lord.
79.
Yes, of the writ petition.
The amended part is there.
Yes. Now earlier it was basically a seniority based criteria. Now it says eligibility merit subject to the following. So
But
now
still-
what they will have to do?
Still, the committee has to be formed by the director personnel.
Person. That remains. Yes.
So the managing director,
Huh.
the committee which was formed
Huh.
on this particular day, this 26/2/2022,
Huh.
it does not relate to the DPC for the post of promotion from E5 to E6, is what we are understanding.
No, my lord.
If we are
No,
wrong.
no, if your lordship should kindly come to page number 327 for a moment, my
No,
lord.
first at page 220, sir, why we are being convinced that way? Page 220,
Yes. 220, my lord.
220
Yes.
at point 8.
Yes, 8.1.
No, 8.0. There are two 8.0s.
Yes.
One just above 8.1. DPC shall interview executives in so and so up to E5. As per revised promotion policy introduced by Part 1 2022. Therefore, officer of the level of ED may be nominated so and so. So that is up to E5.
5.
8.1 being a part of 8.
Yes.
We
Now 11 is the E6.
for 11 now 11 it says DPC shall be constituted by the director personnel. So till this point of time 26 to 2022 the DPC for promotion to E6 is yet to be formed.
Yes, not constituted, but it was done before April, because the proceedings will.
It was done before April. Okay.
No, lordship, that way correct. Absolutely correct.
That part only we will
Because on
calculate.
his date, 26 to 22, it was not there. Subsequently, it was
It
done,
was
but
done
before
later
April.
on.
But in any case, Miller, this whole exercise could not have been started on 26 too. Because they can start only from 1st of April. Because the MD was retiring, therefore it was done. Therefore, my lord, now please come to my averment at page 19, my lord.
Page
180. Page 180.
180, yes, sir.
Yes. The portion which lordship was hinting at, we have said at page 181. Regarding, my lord, that it has to be done effective from 1st of April, that I have said in the opening part. Then please come to 181. In the present DPC, there were no member belonging to minorities as reflected from the office note dated so and so, and approval accorded to the list of DPC members along with the respective categories on 3/3/22. This is the date, my lord, which your lordship will get from record. And therefore, my lord, we filed this affidavit after we were, allowed to have a look at the records, my lord. I further respectfully state that as per clause 10.2 of the promotion policy and its amendment annexed to the writ petition, approving authority was supposed to be director personnel. As a lordship's got it, my lord. Constituting the DPC for approving panel of names of eligible executive, but during the period from inception of promotion to completion of the promotion process, that is issue of the orders of promotion dated 29/3/22, there was no full-time director personnel in the respondent corporation, and the decisions were taken and approvals were accorded by some other officers who was in additional charge of the same. In addition to the above, further it is very pertinent to bring to the notice of this honorable court that above official in charge was appointed by office order dated 5/1/22 for 3 months only. An officer was replaced by another officer by order dated 30/3/22 on the very next day of the issue of the promotion orders, that is dated so and so, that is completion of the promotion process in question. So, my lord, lot of, my lord, gray areas are there in this case. I can only, my lord, as Supreme Court says in barium chemicals case, my lord, malafide can't be seen, it has to be inferred.
The first thing, the thing which has now, till now has convinced us towards you is the non-reflecting of any reasons.
Yes.
Why a person who is having outstanding is brought down to
Not even
not deserving,
not deserving.
not deserving consideration.
And, my lord, most probably, my lord, another point which my lordship may kindly take note of.
Yes.
I think the DPC minus also does not reflect the signature of all the members.
Here, it is said at page 181,
Yes, my lord.
approving authority was supposed to be director personnel.
Personnel.
Where do we find that?
Yes. And that lordships will get at page 58, my lord. Yes, my lord. Huh? মইতো ওলাইছিল নহয় মইতো ওলাইছিল নে ক'ত গ'ল নহয় নহয় ঠিক আছে নেকি 327 টো কি আছিলে
Sure.
Can you give me 1 minute time?
Yes, yes, sir.
Proposal 58. Okay, এই মাত্র পাইছিলেন না?
2, 3, and 4.
8.0, my lord.
8.0. 8.0.
The first one.
8.0. Just a minute. That will be at page 50. 8.
As per promotion policy and the rules for NHPC executive, DPC shall consist of the following members to be constituted by director.
So you are reading page?
Page 220, my lord.
So 220, this is 8.0 is for up to E5.
No, my lord,
When
first
the
one.
promotion is to up to E5. When the promotion is up to E6, then 11 comes into play.
No, 12.
12. 11, my lord, it speaks of that it is to be constituted by personnel, director personnel. 11.1 and 12.0. 11.0 and 12.0.
11.0, it says rule 10.2. Rule 10.2.
No, shall be constituted by director personnel.
So it is 10.2. 10.2.
And 12 makes it explicit, my lord. Accordingly, proposal is submitted for consideration and approval of the director personnel, please.
Gradient shall be consideration of promotion for the grade up to E7 shall be approved. And they say it will be constituted.
In any case, my lord, approval is required.
From the director. So if but they did not form the DPC member the DPC by this order.
Actually, my lord,
Therefore,
it was not mature enough on 26/2.
it could not have
Because
been done.
everything was done by my lord before in the March itself. Because this MD was retiring. He wanted to naturally, my lord, select people of his choice.
That is one part. The other part that you had said was that they did not have the mandatory field exposure.
I am coming to that, my lord. Yes. Now that I have made clear averments, my lord.
Because once we find these things are wrong,
Yes.
then perhaps we can say that the DPC was formed in a hurry.
Yes. Now,
Only
two
then the
aspects,
presumption.
my lord. Now, please come to, my lord, clause 11.7 of the policy.
11.7 at page.
11.7, my lord.
New clause 11.7. Yes.
Yes. Page 81.
Exposure. Yes, we've
Page
seen
81.
that, sir.
DPCL award 10 marks for field exposure as under E5 to 6, my lord, less than 2 years 0, 2 to 6 years 3, 7 to 9 years 5, more than 10 years 10 marks. Now kindly look at our averments, my lord. Para 18.
At page 84.
Page 84.
I'm sorry to interrupt you, but at page 84, I'm trying to understand the gist of it. Page 84.
Yes, my lord.
Field exposure is essential, 12.9, for consideration of promotion to so-and-so.
Yes.
Executive will be required to have field experience in so-and-so. Then 12.9.2 on the number 2 on the table.
For promotion to the grade of E6, minimum 4 years experience.
Now, when the
means
executive
whoever-
does not have sufficient exposure at the time of consideration of promotion as stipulated above, so the consideration can be done. The executive shall necessarily be transferred for field exposure and promotion will be effective only on joining at the new place of posting.
Yes.
By this, they have done away with the mandatory nature of the field exposure.
No, field exposure is essential for consideration of promotion to the grade 7 and 8. Thus, an executive will be required to have field experience at project other than corporation so-and-so, so-and-so. But it doesn't speak of E6, my lord.
E6, yes, it is there.
For promotion to
Grade of
the
E6.
grade of E6, minimum
4 years. Then there is no change. Immediately before that, after the table, you'll find no change. No change. The previous clause says where executive does not have sufficient exposure.
Oh, your lordship is referring to the earlier one, my lord.
No, earlier one, the present
Field
one is no
exposure
change.
is essential for consideration of promotion to the grade of E so-and-so. Thus, an executive will be required to have field experience at the project, power and other corporate regional offices for consideration of promotion as follows. Now, for promotion 2, for promotion to the grade of E6,
minimum 3 years of experience at the level of E2 to E5.
Ha. So
Now please come to the new one, my lord, on the right hand side.
it does not have E6 at the top.
Huh.
It does not talk of any mandatory thing for E6 at the top.
Huh.
Only E7 and E8.
Huh.
They somehow give a go by to E5 and E6.
Huh.
Then below the table, they say no change. So when a person does not have the exposure, it will be according to the old rules. Old rules say
Huh.
executive shall be necessarily transferred to the field for exposure and promotion.
Exactly.
So the mandatory thing they try to take away by the amendment, saying that even if you don't have the exposure, at the time of promotion, you will be given that. But according to the rules, without the exposure, you cannot be considered. You will get zero
Exactly. Now, my lord,
for
kindly
the
have-
exposure part.
my averments, my lord. Please come to page 30.
Yes, sir.
Page 30. A conjoint reading of the aforesaid provision makes it clear that for consideration for promotion to grade E, a minimum of 4-year field exposure is essential.
This is
In the present case, respondent number 5, 6, 7, 8, 9, and 12 did not have the requisite field exposure of 4 years, and they were all required to be posted at places where there is a field work to gain field exposure in strict conformity with clause 12.9 itself. But respondent number 5 was retained in the corporate office upon his promotion to E6 without the requisite field exposure in violation of clause 12.9 and rules of so-and-so amended on so-and-so. The petitioner secured full marks for field exposure, which was reflected at column number 8 of the annex appended to the RTI reply. Amongst respondent number 5, 6, 7, 8, 9, and 12, 3 have secured 0 out of 10, and rest 3 could not have secured more than 3 marks for field exposure. Under the said circumstances, in order to deliberately allot more marks in their favor in such a manner that they are somehow placed above the petitioner, JPC with a malafide intent awarded more marks in interview to them, but in case of the petitioner, he was awarded only 6, less than 8. A comparative table demonstrating the petitioner's position in the case he would have been awarded minimum qualifying marks with respect to the respondent number so and so. So this is the position. So admittedly, my lord, they did not have that experience. Now the other point is, my lord, yes, my lord, I was not given mark for my additional degree, my lord. They have admitted.
That would give you 1 marks more.
Yes, yes.
That would bring it up to 7. No,
Then I would have got, my lord,
73.
74.
74. There were 2 of them, additional qualifications.
No, my lord, I was given 73.
It will become 73.
73.
They give you
Correct,
1 mark more.
correct, correct.
But then still you would not pass the interview.
Because my interview mark is less than 8.
It will become 7 at best. If they can give you the mark for that additional, it becomes
No,
7.
but therefore, end of the day, what lordship will have to adjudicate in this case is that component of 6 and 8. That is where the Millards.
That is where the
Though Supreme Court had said that High Court is not an expert to reappreciate everything.
These
But
are
end of
apparent.
the day, my lord, you have to assign reasons.
No, we cannot say whether it should be 9, 10,
Lordship will
12 or 6 or 8, but we can say that it does not tally.
Decision-making process, not the merits of the decision. Whether he should get 8 or whether he should get 10 or 12,
That
is
we
the
cannot
wisdom
say.
of the authority. But while giving 7, 10 or 12,
But
whether the manner prescribed has been followed.
if I can put it in a different way,
Yes.
whether to pass or to fail, that we can see whether he was a candidate who was required to fail.
Yes.
How much he should have scored is not our
It's
issue.
not a different thing.
That is one. Secondly, giving them the benefit of that removal of the E6 from 12.9,
Yes.
they could have considered for promotion,
Yes.
even assuming that.
Yes.
Still, if they are not mandatorily posted, given a field exposure immediately thereafter,
Yes. That they have
then
not
it
done.
seems that they were only given that benefit without
posting.
adhering to the rigors of 12.9.
Correct.
And thirdly, the additional marks not being given to you.
Yes.
Yes, sir.
These are, my lord, basically, these are all institutional bias, my lord. Now, my lord, regarding that one point, that paragraph, I must point out, my lord. What will I- Para 15, my lord,
Of the writ.
of the writ petition. So this is my last point, my lord. That the petitioner begs to state that clause 8.1 of the promotion policy as amended reads as under, in order to encourage employees to acquire higher educational qualification, leading to improved performance, maximum up to 5 shall be awarded for promotion from E2 to E3 and above on the following manner. Additional degree, etc. Upon perusal of the same, it becomes clear that petitioner is entitled to 1 mark for acquiring postgraduate diploma in energy management through distance education program of Symbiosis Center for Distance Learning, Pune, with 81.5 marks. A maximum of 5 marks can be awarded in respect of the educational qualification in terms of this clause 8.1 of the promotion policy amended on so and so. But on perusal of the column 9 of the annexure appended to the RTI reply dated 26/4/22, it becomes clear that the petitioner was not awarded any mark against the said additional qualification. So, my lord, if we look at the totality of things, my lord, these are not, my lord, innocuous exercise of power. These are all, my lord, exercise of power, which are, my lord, couched in a manner which does not, my lord, reflect any transparency. That is why, my lord.
Yes, sir.
And if your lordships will kindly see at my career profile, my lord.
Page.
Please come to para 4, my lord. That the petitioner begs to state that in 2007 and 8, an internal induction came to be conducted for considering promotion of the petitioner to the cadre of trainee engineer trainee officer. The petitioner participated along with other candidates in the said selection process. However, the petitioner was denied promotion in violation of the promotion policy that was in force at the relevant point of time. Being aggrieved, he approached the authorities ventilating the grievances, but the authorities did not consider this same and in Haryana High Court seeking appropriate relief. Although the relief sought for was denied initially, petitioner along with others preferred appeal against the same, and same came to be allowed by common order dated so and so. And subsequently, the petitioner was granted benefit of the said promotion retrospectively with effect from 1/7/2008 in terms of the direction contained in the order. So, my lord, it's a clear case of institutional bias. So
All the
that
respondents are represented.
Yes.
Private respondents, anybody appears?
Huh?
Whether private respondents are represented?
Respondent number 11. Sir.
Petitioner to take steps.
My lord, one more aspect, my lord.
2, 3, 4 and 17, yes.
Respondent number 11, he has retired on 31/12/2025. 10. So therefore, my lord, there is no difficulty.
No,
So-
only 11 has retired.
I need
The
one
rest of
post
them?
only, my lord.
The rest of them?
No, rest are service, but I need only one post. For review DPC, one post is enough, my lord. And necessarily my prayer would be to antedate my promotion immediately when my juniors were promoted.
No, everybody has appeared.
My lord.
Everybody has appeared. A learned counsel appeared on behalf of restaurant number 2 to 17.
And appear.
Who? You. How can you be 15/11/2022? You have filed wakalatnama for everybody. Wakalatnama খন চাওকচোন ৰেছপণ্ডেণ্ট কেইজনৰ দিছে আছে নেকি ফাইলটো?
I think RKD Chaudhary appears, my lord, for R5 to 16. Mrs. L Devi, same.
ৰেছপণ্ডেণ্ট নম্বৰ 10 RKD চৌধুৰী আৰু কাৰ কাৰ আছে স্যাৰ? দিয়ক গোটেইখন দিয়ক ৰেছপণ্ড যিমান যাৰ নাম আছে দিয়ক।
R224 থেকে official respondent, na? তোমালোক?
হা? ৰ'ব এইটো লিখিব লাগিব। We are,
Representative.
no, we are not dictating the entire order. We are just taking down the attendance so that no one, at the end of the day, if we have to find again service of notice, it will be difficult. Had Mr. K. Chaudhary, learned senior advocate, assisted by Mr. N. Gautam for the petitioners. Yes, sir, you are appearing for? Shri so-and-so appears for, who appears for one? Union of India? CGC my education. That will be the problem if he has now become the DSG and he is representing the private respondents. So he would, it will be difficult on his part. He cannot appear, but L Devi can, yes. You are appearing for 2, 3. And 17. I understand here it is PD Nair, G. Alam, H. Chetri, H. Rahman. Have you filed another wakalatnama or are you appearing on their behalf? Can you tell us? There is an wakalatnama
I
here on
think my
record.
Tanvipran appears for 2, 2, 4 and 17. No, Janu.
Just trying to find it out, sir. 2, 3, 4 and 17 is PD Nair, G. Alam, H. Chetri.
Thereafter we'll find out.
You have filed your wakalatnama? Yes, okay. Mr. K. Chaudhary and Gautam Hegul, none appears for the respondent number 1. Full stop. Which is required. Dear Baru, at episode modify query. Mr. So-and-so appears for the respondent number 2, 3, 4, and 17. Episode. A wakalatnama has been filed for the respondent number 5, 6. You appear for 7. Two, 4. Respondent number 5, 6, 7, 8, 9, 10, 11, 12, 13, 14, 15, and 16. However, none appears for the respondent number 5 to 16 when the matter is taken up today. Full stop. Any more topics?
My lord, therefore, to sum up my arguments, my lord, the assessment by DPC is in violation of their promotion policy, which reflects, my lord, total non-application of mine, or else there could not have been such variation between the assessment of the APR and my lord assessment for the purpose of finding out whether somebody is suitable or not. If there is such a variation, then it calls for a reasons, which is absent. Secondly, my lord, the constitution of the DPC in violation of the prescription, that is that it has to be done post 1st of April. This is also actuated by malice because the managing director was supposed to retire on 31st of March. And in fact, everything was done by March, whereas the entire exercise should have started from 1st of April. Thirdly, my lord, the additional mark was not given to me for acquiring that higher qualification. And fourthly, that field exposure part was not insisted upon in respect of the respondents who have indicated, my lord. And in spite of that, they were promoted. So therefore, on the whole, my lord, from the attending facts and circumstances, what transpires is, my lord, that it's a malicious exercise of power designed to, my lord, defeat the very, my lord, expectation of the petitioner. And in the past also, my lord, when I was a trainee, I had to fight litigation to restore my position. In a sense, there is an institutional bias. Huh?
Yes, sir.
Because of the order. In fact, my lord, the earlier promotions I was given in one go because of the division bench order of the Punjab and Haryana High Court. Therefore, my lord, just to recall the observation of the Supreme Court in Barium Chemicals case, my lord, mala fide cannot be seen. It has to be inferred. So in the facts and circumstances, what is clearly evident is that it is not an innocuous or a bona fide exercise of power. It is a clear-cut case of malice in law. I may not have come out with a case of malice in fact, but it's clearly a case of malice in law. That is my humble submission. Pardon me, Lord, my allegations should be evident from the perusal of the records of the DPC proceeding. That's my humble submission.
The records are required to be retained by you. They are available. There is.
We brought the records. My esteemed colleague, he received the records, and it was decided mutually between us. There is no point in keeping the original records here. It can be photostated, and the photostat copy can be kept in the records of the owner. So that is how it is. It is there.
The photocopy is not available here on records.
Then supply another copy.
Then another copy would be.
It's not here. I'm sorry. But can we have a copy?
Yes, please. So
It was, in fact.
today, a suggestion was made that Mr. Chaudhary would finish it today, his part today initially, and you would be replying on another day. If required, he would reply. Yes.
I was in the midst of another part.
I understand.
There was also election petition today.
I understand.
It's in fire.
So, what would be a convenient date before the 13th? We cannot promise after 13th. So, before the 13th, if some date is convenient to you.
The 9th of January itself.
Yes.
9th of January.
29th. 29th would be time.
Oh, we'll not. We'll put it even on 5th of.
Yes.
5th.
The submissions of Mr. Kane Chaudhary and his senior counsel has been heard. Full stop. Mr. P.K. Tiwari, learned senior counsel, appearing with the assistance of Mr. Swenso for the respondent number 2, 4, and 17, has requested that the matter may be taken up on the 5th of February for his submissions. Full stop. List again on 5th of February 2026 as part heard.
Deeply obliged.
Lord, in fact, two more of my cases are there in the list today, down below. Last two cases possibly. Hearing first and second item. So my lord, one is.
Yes, that was
land
the-
revenue regulation, Assam land revenue regulation.
Yes.
For the revenue. So that I have for advice. Whether my lord would like to take it at back end of the day.
What we will try is we'll try to finish as much as possible. And even if we fix it for some other day, we might, if we have the time, we may take a recapitulation will help.
So therefore, my lord, let it be fifth, sixth February itself, because I'll be arguing the case. Thereafter, this matter I can start.
Okay. I saw Mr. Dasgupta here without,
Mr. Dasgupta, in fact, he was trying to catch hold of me. He was there in the
We-
corridor.
we keep it on the 5th, subject to what,
Be honest,
how, we'll keep it on the 5th, subject to what Mr. Dasgupta says. If you can just have someone find out from Mr. Dasgupta, is 5th is fine. If 5th is fine, we'll keep both the cases, that is item 36 and 37.
I'll also recollect my thoughts in the meantime.
Nabam Tapim was that land matter where,
Yes, Assam, that tribal area, being a tribal, the entire argument was, look, it is covered by chapter 10. How the land of a tribal, in a tribal area, could be given to a non-tribal.
9 tribe.
Then my London friend came with a list of the tribals and said, look here.
No, it was not a tribal.
Or Dafla, whatever.
Is
it
not recognized as a tribe. Now, madam, we propose to take up item number 36 on 5th,
Fifth.
on the 5th of February. Item 36 or 37, beleg ke order hobo, huh?
37, item 37.
37.
Yeah.
Both of them we,
It's a Comment advocate. I think it's a.
on the prayer of Mr. P.K. Tiwari, learned senior counsel, assisted by Mr. So-and-so, let this matter, list this matter again on the 5th of February. 36, you are appearing, sir, in 36? 36.
Yes.
We propose to take it up on the 5th if it is not difficult for you.
Fifth.
1.
Fifth February.
5th is on the 5th of February, 2026, with the consent of the council for the respondents. Yes, we'll take it up on the 5th. Thank you. Mr. A. Dasgupta, learned senior counsel, appears in item number 37. Huh? And Mr. Gogoi,
Will not be, mutually we agree that each of us have forgotten everything. What it is.
my plight. Mr. Gogoi appears for. Huh? On 5th.
Obliged.
It ever refresh kori dibo, huh?
52, 50, 50, 50 to 52.
52 to 52. Lot of
Not,
twos.
Your Lordship kindly peruse the order dated 11/8/2025.
20.
11/8/2025. Thereafter, Lordship, they took time since 3 occasions. But no affidavit has been filed. In fact, Lordship, very simple case. Their Lordship, district, State Scrutiny Committee has already recommended the name of the present petitioner as grade 4 employee. But thereafter, Lordship, their service has not been provincialized.
There is no one from the elementary education department, it appears. We'll take it up after 5 minutes. Let them realize that the earlier case is done with. Let them come back. Ask someone from the elementary education department to be here.
Lordship.
Take it up. Timing. তাহাঁতি ইটো কেছ চলি আছিল ভাবিছোতো earlier case to put scroll ta dite Mr. Kaushik. This is item 50 to 52.
You are yet to receive instruction.
Yeah, no, that will put someone else in trouble. Mr. So-and-so submits, he has received instruction.
That was on
That
August
was in 11/8/2025.
তাৰপিছতো তিনিবাৰ টাইম লৈছে।
You'd like to have the file or the file is not here? File is not here. Mr. P.N. Sharma was perhaps had stated that this has been received, the instruction. Find out from the department. Because thereafter, there are 3 orders saying that you are allowed to file the affidavit in opposition. If the instructions are there, we can follow in this manner. If the instructions are actually, if they are not coming from the department through earlier modes which were applied, we can revert back to the primitive time when we can have
Next week, Lordship.
we can have a primitive way of someone carrying the piece of paper from the office to the court. If not by the electronic mode, just find out if the instructions are actually arrived. We'll have it after some time.
May I please, Your Lordship?
Yes, madam.
My lord, compassionate appointment, my lord.
Mm.
On the last occasion,
Mm. But now can there be any compassionate appointment?
Earlier it was rejected 3 times,
not rejected, my lord.
not considered due to want of vacancy,
Want of vacancy.
not considered due to want of vacancy.
The death occurred when? The demise? 2017. 2016, 2016,
The latest one is, my lord, page
2015.
34.
Huh?
Latest one is page 34, my lord.
Is 34.
My lord.
Why did they reject it this time?
My lord, serial number 33, Vijita De, that is a,
Want of adequate?
one vacancy, my lord.
Again.
Again, 4 times, 4 occasions, the petitioner's name was placed. First 2 occasions, they said, want a vacancy. Third, time lapse. 4th time, again, want a vacancy, my lord. And no, her case was not considered in any other department. That is also a plea, my lord.
But even then, can the case be now considered in view of Devobrat Tiwari? That you have to convince us now. From 2015, we assume the
My
death
lord.
is of 2015.
Issue is, my lord.
10 years, 11 years.
My lord, my petitioner's issue it, my lord, both the parents were teacher. The petitioner's father earlier died in 2009, leaving behind petitioner and the mother. Petitioner mother also was a teacher. She died in 13. So petitioner is the only legal heir, my lord. He is alone, unmarried, and nobody, there is nobody to take care of, my lord. My lord, no, she is not.
The family pension she is not getting.
She is not getting any pension.
As an unmarried daughter, she is not getting pension.
Not getting a pension. That was.
That is different issue. If she's not getting,
Bring that issue in this also. If that issue comes in, compassion will be dampened.
My lord. No, my lord, that I have.
There will be some water poured on that compassion part. The compassion would be only if she has nothing to survive on.
My lord. That.
Even if we do not take Devabhrata Tiwari to in the context of this case, compassion would only come in when there is nothing for her. She has made an assertion, there is nothing in it for her. And it is not only government, it has to be the education department also, which can slowly come in from the corner. Yes, madam.
Regarding that, my lord, I have.
Can you tell us if this the 2 parents, the parents of the petitioner, they were serving in the department? They were serving in the education department. Now she is a lady, aged 31 years. When she was 21 years, the father expired. The father and the mother expired. Unmarried daughter. Any family pension provided? Or while making the application, has she given the list of the what do you say, the property left behind, the earning source? All these have to come into play to see the compassion part. If we go by Devabhrata theory, we can say So and so covered, close, no relief. You don't want to do that. That will be one of the aspects, but if you can come up with what was the her financial status at the time of death of the mother. You are seeking against the mother, not against the mother, in lieu of the death of the mother you are seeking. So at the time when the mother expired, what was the application file? What was the status, economic status shown? It has to be something which should give a rise to compassion. 21 years old, unmarried daughter. In that context, at the request of the learned counsel appearing for the respondents, list this matter again on. We'll keep it on 16th or 17th. When? 16th of February 2026. By which time the respondents would be at liberty to file their affidavits in response to the writ petition. You are filing it when? Tomorrow. Tomorrow. In case the time permits, petitioner would be at liberty to file her rejoinder to the affidavits filed.
Obliged.
Those item 53.
My lord, in this case, my lord, case is pertaining to family pension. And as per the order of the earlier writ petition, my lord, there is a direction to equally divide the pensionary benefit between two wives, my lord. So their part, my lord, I am not praying, my lord. Our part, my lord, I am praying that so far our part is concerned, the benefit may be provided to us.
There cannot be two pension payment orders.
My lord.
So now Mr. Cholia has to spread the light.
Lordship, the case was the eldest surviving wife, Lordship, she is not cooperating. This is the problem which we had asked. For
You were also required to tell Miss Esquire, Director of Pension. Who's paying for pension? Yes, sir. Do you have the other half of the PPO?
No, that is with the petitioner, Lordship. The bank's copy.
They have regarded that photocopy, but to cancel original.
No. Whether the said authority can act upon the scanned copy of the other half of the PPO, you were required to ask. You were requested to find out. Now, yes, of course, the original PPO has to be cancelled. With the observations made by this court, saying that she is not cooperating, therefore the original part of the PPO which she has retained. Once a document, official document is lost and you need to say that it is no longer in force, what do? Wait to search out the original. Cannot be. We are prolonging the matter for nothing. Tell us a way out.
But in the meantime, my lord, first one is, my lord, respondent, my lord, is expired, my lord.
Oh, she has expired.
Expired.
From where she will return? First wife gone.
No, and Lordship, the record of, from what I was told by the treasury, the records have been misplaced because of there was some flood. Now we have a photocopy. Now on the basis of the photocopy, the treasury officer had written to
The submission made that the first wife is.
Yes, Lordship.
Recently, my lord.
Now,
I can.
Now-
I have been informed by the treasury officer that they have computed also, but certain details are required
Of the?
of the
From the?
history of the details of the petitioner or the pensioner, Lordship.
So
that is required from the director of pension. Because the treasury officer had lost it because of some flood. Lordship.
Done.
So now they have a photocopy of that, scanned copy, Lordship, that was submitted. So on the basis of that, if by learned, the director of pension can take a call, then they have already made a calculation.
The person has expired. The originals are lost. Here is an undisputed second wife. Law says if there are 2-3 wives, after the first or second one would get it. You are not challenging, you are not assailing, or you are not commenting on the legality of the marriage. You are taking it to be a valid one because you are trying to help. So, cancel the first one since she has expired. How can we be sure that the first wife is gone?
My statement may be recorded, my lord. My submission may be recorded, my lord. I have been told that the first wife is.
Something more. Something more.
my lord.
Some entry from the
Because my lord, I can,
entry from the Kabristan with the name, some death certificate,
death
something.
certificate, my lord,
One of our sons, an affidavit by your petitioner,
petitioner.
something
That can be, my lord.
on the date, time, huh?
Nine.
Whether anyone else will be also eligible lordship, so.
There is no minor. my lord.
No, but even if they are legal heirs, what will happen is the second wife has to get it. And the other wives, initially when we read this order, we were thinking of acting on the lines of the compassionate pension scheme. Someone makes a complaint, you bifurcate and you tell the portions.
Yes.
But this is prior to that,
Yes.
that compassionate scheme. So ipso facto, we
So,
cannot
madam,
bring
in
it, but
the-
mutatis mutandis, we can bring it in. Once the first wife has expired. The second wife would have the
Yes,
authority.
that. But only
Mr. Pegu, can we just try to bring this to a ending? Now she cannot claim what was already given to the first wife. It is gone. That part is gone now. Next month on, maybe she can have some pension. When can you file that affidavit in opposition? That additional affidavit to bring on record the demise of the respondent number so and so.
My
When?
My lord, within 2 days, my lord, I will file because. we
When
have-
were you informed?
My lord,
When were you informed about the death of the respondent?
my lord, 1 week ago, my lord.
You did not file the affidavit. Can
My
you
lord,
file it in 2 days?
Yes, my lord, I did not file. My lord. So, my lord, I will file within 2 days, my lord, on next Monday, my lord, matter may be taken.
This court has referred to the order dated 5/1/2026 passed by this court in this writ petition, full stop. Today, Mr. G. Pegu, learned government advocate, and Mr. H. Aliha, learned standing counsel finance, have submitted that although the original documents in the Treasury Office has been misplaced during a flood, a scan copy is available. And in case the pension department agrees to proceed on the said scanned copy, comma, the matter may, it may be possible to bring the matter to a quietus, full stop. The learned counsel for the petitioner has submitted that he is under instructions that the respondent number so and so has, respondent number 5 has expired recently, full stop. He prays for some time to file an affidavit to bring on record the aforesaid fact, full stop. List this matter again on the 11th of February 2026.
My lord, may I place some early date, my lord?
Fine.
Or
If you have
any-
filed
any
11th
other-
of February.
Any other early
yeah.
date, my lord, 7th or 8th, my lord, like that, my lord. Some early date, before 10. my lord,
7 and 7,
Or 8, any date, before 10,
8
my lord.
is impossible.
My lord, before 10, my lord.
8 is impossible. Okay, 9th of
My lord, man.
9th of February. Full stop. The learned counsels for the department or for the respondents are requested to have their instructions ready. Yes. No, whether it is possible to proceed or not. That you bring a concrete thing. We have got a photocopy. We have to cancel the original. Original gone in the for him. It is gone in the flood. For the petitioner, it is gone with the wind. Huh? Government is here. You are the government. Multi-armed government. Use your arms. 50 to 52. No? Any updates, Mr. Kaushik?
My lord, item number 50 and 52, my lord. Affidavit has been sent for validation.
Yeah.
51, my lord, it's sufficient.
By when can?
Cover.
Hmm?
Cover.
The affidavit should cover probably
It will cover.
because they are not being considered for provincialization. So why they are not considered? When can we have it?
Let it be next week, madam.
Choose a date. Tell us a date.
Cut off it, Lordship, any.
5th of February?
Fifth.
Mr. B. Kaushik, Learned Counsel, appearing for the Education Department, has submitted that the affidavits have been sent for vetting and can be filed within a period of 7 days. Accordingly, list this matter again on the 5th of February. Full stop. Mr. M. Khan, Learned Counsel, appears for the petitioner.
Item 54.
With your lordship permissions, I would like to state that my learned senior advocate M.H. Laskar is out of station today due to some unavoidable reasons. So, your lordship, I respectfully seek a date may be passed over for the day. The matter may be passed over for the day.
You have filed your wakalatnama. And we refuse to pass any orders. I remember the name. There were about how many names? Somewhere around 300 names that we were required to remember. One of them is this. List before any other bench without me.
Item 45.
Any other Nokoba list before a bench without me? Any other?
This is contempt petition, my lord.
Yes.
I have taken justice service and file affidavit. An order has been passed. So kindly peruse the last order. Yes, relates to non-payment of pensionary benefit losses.
Yes.
Then, my lord, my lord, in this case, my lord, 6 may be deleted because he has no role. 5, because he has no role in this.
By the name, my lord, K.S. Kapurna in the office.
She has taken steps. You are appearing for him.
But my lord, they have taken when I took.
You are
case,
appearing
my
for
lord,
whom? Who instructed you? Okay.
he said.
Sir, the copy of the contempt petition on there. Now I'm going through that. It is revealing that there is no such.
We have collected the name from Google, my lord, then,
There is no.
and he has accepted the notice also.
Yes, Kapurna.
Learned Counsel, Ms. K. Devi, Learned Counsel for the petitioner has submitted that the respondent number 5 is not a necessary party to the present contempt petition. Full stop. Accordingly, she prays that the said respondent may be struck off. Prayer not opposed to by Mr. You are appearing by Mr. A. Chaliha and Mr. B. Kaushik and Mr. B. Sharma, by A. Chaliha and Mr. B. Kaushik, comma, and submission being made by Mr. B. Sharma, who appears, who is the standing counsel of the Accountant General, comma. The respondent number 5 is struck off from the memo of parties of the present case, full stop. However, for the sake of convenience, the seriality of the other respondents are not being disturbed and shall be maintained, full stop.
My lord, 3 and 4 till now has not been appeared. Let them come, my lord.
Have you served
Yes,
copies on
yes,
them?
yes. Justice service we have.
But then again, if the same thing comes up,
No, they are, Jagadish Brahma is director. I know, my lord. I have collected the name. And Zahirul Islam is the inspector school.
Mr. Choliha, you, and where is the show cause reply?
Earlier also he appeared.
The case is basically a petitioner has been told to given the benefit of a whole pension scheme. And
Ah.
she's a teacher. Now, When the, as per my instruction, I received my instruction. So in the instruction, it has clearly stated that we are waiting for the proposal from the education department.
Just file a one-line affidavit saying we are, as of now, we cannot take any action. We strike out your name immediately. Mr. Kaushik, your department is not taking to file
The
the.
person who is suffering, not getting this salaries, my lord,
Huh?
old pension scheme, old pension, my lord. How can the person will survive, your lordships? And Boroland, director of Boroland, may
Yes,
kindly be
Mr.
appear
P.
before.
Kaushik has prayed for an accommodation to file his reply to the
Not
allegations
actually,
made,
compliance of this court's order.
to reply to the allegations made in the contempt petition. Full stop. None has put in
No.
appearance for the respondent number
3 and 4.
3 and 4, full stop. It is provided that if no response to this petition is found on the next date fixed on behalf of the respondent number 3 and 4, this court would be constrained to pass necessary orders to ensure their presence before this court, full stop. Ms. A. Devi, learned counsel for the petitioner, is permitted to forward a copy of this order passed today to the respondent number 3 and 4.
Yes.
Give them a copy. Let us see what happens.
Yes. 54.
50? 54. We were just starting with the non-appears.
As per last official, they have not taken step upon.
My lord, lordship kindly peruse the one order that is 22-1-2025. My advocate's clerk wrote respond number 5. We have taken step, it should be respond number 4. And this case is related to non-payment of salary, my lord.
Who is respondent number 4?
4 is, your lordship, headmaster.
Eh?
Headmaster, Dulahal High School, District Nalbari.
And education department is not a party here.
Yes, there is.
They
1,
are
2, 3, 4, 5. Finance. Current salary is also, I have, my prayer is to provide current salary, my lord, and he has filed representation
Eta
also.
scroll diok. Item number iman eta scroll diok. Secondary education. Council secondary education. Hobo etao 9 minute ase neki. We'll try.
He.
After some time, we are giving a scroll. Let us see if someone from the education department comes. Oh,
So don't cry now.
our apologies. Yes, tell us. Huh? Item 35. Kiman diye agate order koili. Contempt of matter. Oh, but then you keep it on
Contempt.
12th. 12 no order to sile bo jodi kiba weeks or time disu tetia hale teneke adjust kori dibo. Yes sir, tell us. Why?
My lord, I am earlier.
Is waiting for pension.
Not pension.
Salary. A year salary from when to when?
Till today. Till today, I have not been received salaries. Why he has submitting like this, I don't know. Lordship, because earlier also I come before this honorable court and obtain order. I know the order.
Yes sir, madam, kindly tell us when was your appointment?
Initially, actually what happened in 1999, subdivisional elementary advisory board was issued an advertisement and he was selected.
No, you were appointed on 4/12/1999.
Yes, my lord.
Then,
My lord, I have been received up to 2006. I have been received
Very well.
salaries.
Ah.
Then he has been. Then it was divided by Boroland and Nalbari, my lord.
Ah.
Then he has been shifted to the school, promoted to another school, high school, which is situated at Boroland, my lord.
Ah.
Till then, he has not been received salaries. In the meantime, I filed case before this honorable court. Honorable court.
Where is the order?
An order also, my lord.
Where is that order?
That is, my lord, page 55. The relevant portion is, however, considering the pair of the petitioner, 55, 56, 57.
Yes, you were sent before that committee.
Committee, yes.
Then what
Committee,
happened?
but he has appeared twice, thrice committee, but
Ah.
no conclusion has been made. That is the case, my lord. Until today, he has not been. Lordship can kindly peruse this 67.
67.
Yes, my lord. Inspector School wrote a letter to the forwarded letter to the Director of Secondary Education. That is 2025, 6/1, 2025. Hmm? 62 হেৰি মমতা বুজাই দিছে কম আগতে ইন্সপেক্টৰটো গৈছো
Yes, sir. Horendra being one part of it.
68, then 68, Director of Secondary Education forwarded letter to the Secretary of the Government of Assam, my lord.
Lordship, moreover, here that it is should also be a party.
You have not made BTC a party, madam?
No, BTC has, because the
He
corresponding
was originally in the BTC area.
originally,
Then
then
when the
he-
BTC was created, he was transferred to the
Yeah, Nalbari.
non-BTC area.
Nalbari, yes. BTC is not
No,
nice,
no,
sir.
he was transferred. Now, whether the transfer was correct or not, and whether he was actually, whether some legitimacy of an appointment can be given to him. I think the BTC, if the BTC is not there, we cannot raise the question. If we cannot raise the question, it will be a disputed. Why are you not paying the salary? Because,
No, Lordship, he
oh
can-
yes, why are you not paying the salary? Hmm. A non-approval of the government to what?
As per report of the headmaster, Donald Scotia, only Burman, Burman is from the date of his up to March 2007. But after March 2007, there was a issue that separate is there.
Now, madam, your appointment was by the non-BTC administration.
Yes.
Is it by the Assam government? Then the transfer order is issued by the BTC government.
No, my.
Those transfer orders were set aside. Those transfers were held to be illegal by this court.
No.
Transfer from BTC to non-BTC.
Lordship will kindly peruse the order dated passed by this honorable court, 9/3/2018. Petitioner contends that he was selected for the post of second para. Assistant teacher in ME school under BSc authority pursuant to which he, when he was appointed initially under the BSc, my lord, he got the salaries, my lord. After that, he transferred to the school which is situated to Nalbari.
Who transferred him?
BTC, my lord.
BTC
BSc.
transferred him to where?
Lordship kindly.
No, just tell us to where?
No,
Where was he
not-
transferred, sir?
Nalbari, Inspector School, Nalbari transfer.
Inspector of School BTC, if you see the order, kindly see the transfer order, madam. We are trying to help, we are trying to
Yes,
find a
yes.
way out. We
My
are-
lord, give me some more time because I have not gone.
No, you have to go through it, you have to tell us this.
Yes.
BTC appointment BTC transfers him to
Uh,
where?
Yes,
BTC transfers him to a non-BTC area.
area, yes.
Is this transfer possible? If not, if the transfer is not possible,
Hmm.
Government of Assam will not be liable. You are a BTC person. Stay with the BTC, take salaries from them. If it is possible, we can ask them for a post facto approval. Why not a post facto approval to a transfer done by state, by a government, by the BTC?
BTC.
Simply, I did not approve it, will not end it. Why the approval cannot be granted is a question that will come up next. But simply saying that I have not got my salary because I was transferred. This is not a transfer from
Not because
from
of
Guwahati
transfer,
to
my lord.
Rongia. Withdrawal of post?
Page 58. One report from the inspector.
Page 58.
As reported by the headmaster.
Just a minute.
As reported by the headmaster Roland High School by the that Tejavi petitioner bench had refused to pass the salary bill of the petitioner due to non-approval order of the withdrawal of post from the higher authority.
Just a minute, Krishna.
Maybe that may the reason.
What has happened is this: when you were transferred from Kolaguru Vishnurabha High School to
School.
Dolahal High School, the post you were transferred along with the post.
Along
So
with
the
the
post has to be withdrawn from Kolaguru
Kalaguru.
and given to
Dolahal.
Dolahal. That was not done. If that is not done, your post remains at Kolaguru. Someone will be appointed there and drawing the salary. Dolahal does not have a post. Where do you get the salary from him? So either you say that the transfer
Lordship, para 7 in this petition 58,
Huh.
by an order, White memo dated Inspector School, Nalbari, adjusts his service and regularized against the vacant post of Anjali Chaudhuri, assistant teacher, now
can it be
expert.
done?
Same school with effect from the date of.
Can it be done?
Again.
Again.
Again, my lord, the instruction of the higher authority, the salary of the attached adjustment employee were stopped 2007. Then order dated, and accordingly to the pay of the petitioner was also stopped, but an order dated 2007, pay stoppage order 7 was vacated by the then Inspector School, Nalbari, and
Yes,
allowed to draw his salary against the post of Anjali Chaudhary.
Unless you
He
prove-
has been received salaries up to 2006. The school did not pay the
The
salary.
department has to tell us.
School. Yeah.
The department has to
Because
tell us
petitioner has
why Dolahal is not paying the salary even after the inspector of school has withdrawn. Why the salary should not be paid? When?
in page 63 also it is stated, my lord. After he doing
This is the second round of litigation for the petitioner.
Yes, yes.
Ms. K. Devi, Leonard Council has submitted that the petitioner is surviving without salary, although he is discharging his duties at the school concerned, full stop. The Leonard Council appearing for the Education Department has no. Mr. P.P. Dr. Leonard Council appearing for the Education Department has sought for a short accommodation to have his instructions on the letter dated 7th of June 2017.
In page, my lord,
What does the expert committee say?
report of the Ranjit, my lord, lordships, kindly see the annexus 1763. It is stated that now they have, but it is known why then headmaster. Now present institution has agreed to release his salary if the higher authority is allowed. Due to their mistake, the petitioner did not get the salary. নকৰো নালাগে এইটো আৰু পাৰ্টি কৰি থকা
Yes, what will you find out? Can you have page 64? What will you find out? 64.
submission of status, present status.
Last line.
Yes, ma'am.
Last but for no, fourth last. That I took charge of the headmaster with effect from 2000 prior to my taking charge. Why headmaster did not pay salary, I don't know. And 612025. The learned counsel for the petition has submitted that as per annexure 20 of the writ petition, comma, his salary was not paid, was not released as government approval was not received for his transfer. No, was not received, full stop. It is not clear as to on what aspect the government approval was necessary. And the reason for not giving such approval if any such approval was required, full stop. It appears that the petitioner was transferred from the BTC area to the non-BTC area through an order passed by the then BTC authorities. Full stop. List again on 13th of February 2026, by which time it is expected that the counsel for the respondent would be supplied with the instructions. Yes.
Obliged.
Asila, PKT হৈছে আছে। No, এইটো এক্সপায়াৰ কৰিলে, তাৰপিছত তেওঁ ইংগেজ কৰিছিল। কনকলিটা কি কলিতা যে তেওঁ ইংগেজ কৰি থৈছে। এইটো লাষ্টত মই ইয়াৰ আগতে পাৰ্ট হাৰ্ট কৰিছো তাৰমানে। আৰু ইয়াৰ আগতে মোৰ বহুত হিয়াৰিং হৈছে এইটো। Yes, দিয়ক।
38.
হা? 38.
38.
Until also as per last order, we have to file affidavit also, depending that the record is not there. That affidavit is have to file, otherwise also exactly similar issue. Exactly similar is from the same institute, today two judgment was delivered from the FEMA bench by my lord justice. Exactly similar issue, judgment will cover, I will place the judgment.
My lord,
He is not known.
my lord, yes, I am not aware of that.
No, that is why I'm saying that would you like to go through the judgment passed?
Yes, yes, I can go through.
Mr. K. Gogoi, Learned Counsel, appearing for the Higher Education Department, has submitted that although the affidavit as required to be filed regarding the absence of record, comma, today a similar issue has been decided by a coordinate bench. Full stop. The Learned Counsel for the petitioner has prayed for an accommodation to go through the decision stated to have been rendered today. The decision rendered in WPC number
156 of 2025, 2015. That is 2015 lawsuit. Lawsuit 3808 of 2015 lawsuit.
he is waiting for it to be recorded in the order so that he does not have to take the pain. List again on, when do you want it? When do you want it?
Last minute,
When do you want it?
as you lordship. Next week.
It is for you to go through the judgment
Next
and
week,
tell
my
us how can it be our pleasure.
Then my lord, next week.
Next week, did your next week what you are? 30th of January next week হে ক'লে আজি 27 নহয় জানো 6th of February. 6th of February. Mr. Gogoi may have the affidavit prepared for filing in case the matter is submitted to be not covered by the learned counsel for the petitioner so that this present matter can be taken up on the next day. If it is covered, it goes. Otherwise, have the affidavit, then we'll decide it.
Obligement.
To kiman?
39 hearing matter relates to departmental proceeding. And only 5 minutes is left, my lord, whether it is possible.
Just a minute. You were terminated terminated when?
Terminated in 2012. আমি সম্ভবই না এটা ডেট কৈ দিয়ে
Yes, sir. Going by the synopsis, was the procedure followed? He may be all guilty. He may be all guilty. Unless it is a case of corruption.
No, but my lord, here he is the employee of my lord, the service officer. He is the employee of the service officer, not the government.
I understand.
And that
Even
was the
then,
pending-
if the Sarva Shiksha Abhiyan is a state, and if it is considered to be state, where we can exercise Article 226,
My lord, it was
and if we find
Yes.
that the termination has been done without following the due process of law, which would basically come down to one point as to whether he had ample opportunity to dispute the charges, to refute the charges. Then
It was given, man, the spirit of that particular.
then if again if he has been dismissed by 6/8/2018, spirit of whatever we are talking about, the spirit, we are not saying that every step he has to be given a chance to appear, to have a look into every piece of document. No, we are not saying that. But
That rule is otherwise, my lord, not directly applicable.
it may not be.
Follow the spirit.
May not
Give
be. The
opportunity when-
opportunity of what? That opportunity has to be
No, to submit written and all, my lord, was given.
so be it. But the allegations, whatever it was based on, did he have all the documents with him? On the charge must have been based on something.
Yes.
He gave a completion certificate or something. Someone lodged an FIR. Then the bail petition records that the completion certificate was not issued. That is what we have just understood. And then he was
No, there is
given a
no-
discipline.
There are various charges. I will place everything.
would-
Not only that charge, even if we, my lord, there are some records now, my lord. The honorable court directs us to produce some records. That record is not available. It's not traceable, my lord. In fact, my lord, while my lord, he was on leave, my lord. He did not even, my lord, hand over those documents till date.
That is not the stand. That is not the contention made in your.
Last order.
No, we are just trying to serve. What we will try to do is, this court tries to do is, we will not substitute our views for what they have taken. What we will try to see is whether you had ample opportunity of defending yourself. If you had one, they had the right to take a call unless it is irrational.
Yes, ma'am. Well, Lordship, kindly appreciate one thing.
Hmm.
Initially, they took a stand that, my lord, we are going to conduct an inquiry to maintain the fairness. And the very beginning language of the order, my lord, in terms of the order of the court, in conformity with Article 311(2),
Hmm.
and to maintain the fairness vis-a-vis the natural justice,
Hmm.
we are proposing to conduct an inquiry.
Hmm.
Now, in their affidavit, they are saying, my lord, no DP is necessary, which goes to show that there was an irregular DP. And what procedure you have followed? Minimum opportunity be given to me. I was not allowed to, my lord.
Can we have it on the 10th?
10th, my lord. 10th. May I request, my lord?
Yes, yes.
Subject to your lordship's convenience.
No difficulty, sir.
My lord, lordship can take up the matter on 12th.
12th.
12th,
Okay, 12th.
Thursday.
Yes, I have no.
List this matter again on the 12th of February 2026.
And
And you have we would not require any further records of the proceedings as such?
If that I can place.
No, we are just asking.
We have placed everything.
It is on the 5th of February, on the 12th of February
My lord,
2026.
one thing I must say, my lord,
Hmm.
the first query the lordship has made, whether, my lord, Sarva Shiksha of Abhijan is a state, and whether I am holding a civil post. That was observed by the court in earlier writ petition that I am holding a civil post and I am working under a state. Therefore, that question doesn't arise, my lord.
When we said that when we find you to be a state,
My lord,
when we find you to be a state,
my lord.
then we will look into the principles of natural justice. If it is a personal contract, then we may say that we are not inclined to.
What is
If
the
it was a
finding?
private agency, SSA is not a private agency, sorry.
My lord, that portion was answered by the court in earlier writ petition. Same stand was taken. It is a termination simpliciter in terms of clause 5 and 6.
Our that observation was only to impress upon Mr. Gogoi that we find you to be a state and you have to answer us. Huh? It is. But then
I will
the
address
charge
the
of
court.
public function and all that. If you are a state, you have to follow it.
Yes,
Whether public discharge of, whether it is in the mode of
Yes.
public discharge of public
and
function.
that part of the finding was not never challenged. That it is finally
Insurance certificate appear
obliged, your lordship.
পাঠাৰ হ'ল যে পিকেটি ৱাইছৰ পিছত আহিলে ইনচুৰেঞ্চৰ এপিয়াৰ কৰিছিলে এইখন তাত থব মোৰ হাতত থাকি
Whether lordship is going to keep it as part heard?
No, on the 12th we have a bench.
My-
We are here in Guwahati.
My lord, my lord.
If we are holding the bench, definitely we'll
My
take
lord.
it up. Thank you.
Obliged.